Good morning, good morning, good morning, amazing law nerd. It's good to see you. I realize for some of you, it's like good evening, good afternoon, good all the things. We have a lot to do today. It is Thursday, February 5th, 2026. We are going to court today, but we have a couple updates before we go to court. And I was in court this morning. My hair is not courting. I was in court this morning. The best part about being in court now, like EDB no longer being in court on her own cases, the best part about being in court now is, yes, I was in the same hoodie that I'm wearing to stream. So I got to jump from court to stream because I got to be on my phone. It's just so nice to be able to remotely attend hearings, figure out what's going on, and then be like, ooh, what are we doing? What are we doing? We're in court. So we're going to talk about that hearing real quick. I will do more updates on that case in a minute. So we have a couple states to jump through today before we go to Tallahassee. I have an update from our members only live. So I'm going to catch all of you up a little bit on Emily crashing out this week because I have an update that I want to share with everybody. And I have an update from yesterday. So we have lots to do. Law nerds, are you ready? Let me know where you're coming in from, what you're drinking. I made a second cup of coffee. It's going to be like that today. A second cup of coffee was warranted and needed, but we're going to roll the intro. We've got a couple housekeeping updates. For those of you that are like, Emily, what's the tea? I will tell you what's the tea. Then we need a brief stop in Idaho. Then we are going to Tallahassee. Well, okay. Utah, Idaho, Tallahassee. We get miles for each, right? So just a couple quick stops. Let's go. And this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. All right, law nerds, what's up? Let's start in Utah. I think it's fair to start in Utah because we code redded yesterday. I buffered, I code redded. I was so upset. You know I was upset. For those of you that are like, Emily, what happened yesterday? We were covering motions still going on in the Kouri Richins case. That case is starting jury selection literally on Monday. They've been going through the beginning phases of jury selection. At some point, if this is ever unsealed, I'm just curious, like how many law nerds got the jury questionnaire and we're like, excuse me, I'm a law nerd. I cannot. I'm so curious, but one day we'll find out because the law nerds will just DM me and be like, no, I totally got that questionnaire. 2, as they are going through this process, the defense was just like, oh my God, the prosecution threatening the witnesses. And I was like, you guys, come on. What are we doing? Just Miguelina, literally just this second. So I was so frustrated. And then I was like, why would the defense even file this under seal and then give the sealed exhibits to the media? Like, it didn't make any sense to me. And I was so mad about it. I was like, this doesn't make any sense. Also, why would you do this? Also, don't give the media like sealed documents. And then I said, look, it was filed on a Sunday. And because it was filed on a Sunday, maybe the documents were on the public docket before they got sealed. And if the defense reaches out to the media and is like, hey, we filed a new document. I mean, that's fair. If it's on the public docket and they just get a heads up about it, fair's fair. It's on the public docket. Though the media did say provided to us by the defense. So I think they probably also just emailed it to them, which is what it is. But if it's sealed, it's fuckery. So yesterday after stream, you saw me look at the docket, y'all. We pulled up the docket during stream. I'm just wondering at this point if somebody's like watching stream and waiting for me to stop and then filing items. That would be ridiculous, and I'm joking. But after stream, there were a bunch of docket items that popped up on the docket. And one of them was the defense response to the prosecution's opposition. So in the Richins case, the defense filed their motion to give us all your shit. Give us all your shit. Give us all of the messages between everybody and every trial witness. It was a huge mistake. It was a hugely overbroad. We're going to have to just put Julia Roberts on the soundboard at some point. It was a massively broad, not tall, broad request. Too broad, I think, obviously. And so the defense filed their motion and they're like, the prosecution's intimidating witnesses. Those words don't mean what they think they mean. I don't read the text messages the same way they do. And yes, if witnesses are subpoenaed to go to court and they refuse to show up in court, the prosecution will say, Your Honor, we subpoenaed this witness. They were supposed to appear in court this day and time. They were not here. Will you issue a body attachment, a warrant? Will you issue a warrant? They failed to appear. It's a lawful court order on the subpoena. And we're going to have the sheriff give them a ride to court. Then they don't have to worry about traffic, man. They got wee-woos. But they have to sit in the back of a cop car. Ooh. So we're going to just helpfully get them to court. And if we don't get to them today, we'll make sure that they have accommodations so they can come to court tomorrow. I don't know if we're going to be able to make sure they have like a toothbrush, but we'll be able to make sure that they have accommodations. Now, the defense maintained that this was threatening of the witnesses. I think it's fair to say this is the consequence of this action. The defense was saying, but the prosecution was saying if they didn't come and do witness prep, if they didn't come and do the interviews with the prosecution, and I don't think you can issue a warrant if somebody doesn't do an interview. I think you can only issue a warrant if somebody doesn't show up to court on the subpoena. However, if you subpoena them every day of a 4-week trial, you can make them show up every day and sit in the hallway on a bench every day. Hey, we'll order you back tomorrow. So the defense filed that motion. The 2 exhibits were sealed. I crashed out because I'm like, these are sealed. Why does the media have them? Bleh. Then the defense yesterday, after we finished streaming, filed, and I mean, I guess it could have been while we were streaming and it didn't hit the public docket until later. Pick the answer that's funnier and just go with that. I'm fine. And they filed their response to the prosecution's opposition not under seal. Now, the prosecution filed their response under seal and filed the motions, filed the exhibits under seal, and filed the rest of the documents under seal. And in the defense's reply to the prosecution's sealed opposition, do you know what they said? They said, none of this should be sealed. So then I was just like, what? Y'all? The defense is like, we never wanted any of this to be sealed. It shouldn't have been sealed. The defense didn't ask for it to be sealed. The prosecution asked for it to be sealed. So, to the defense team, my apologies. I crashed out on y'all, but it seems like you didn't seal it. It seems like the prosecution requested that it be under seal. So the defense filed it, and it got sealed afterwards. Look, I don't know why, but also when I saw that the defense filed it and said this should all not be under seal, I was like, I mean, okay, maybe they didn't seal it, and then went back and looked. So it is possible that in the time that they filed it on a Sunday to the time that the court sealed it, that it was unsealed on the public docket. There is a very real and honestly likely possibility that there was a window of time that was not sealed. So giving that the most generous interpretation possible, it is possible that when the media got these, they were not under seal. So, as to the crashing out about sealing a thing and giving it to the media, apologies. If you did not do that, then that is not fuckery. I still think the motion has a fuck ton of hyperbole, and I don't read that situation the same way. However, I'm less mad if they didn't file it under seal and then give it to the media. Now, I'm not so sure. I'm not so sure that they didn't also intend for it to be under seal. And Lyndon, this is what we're going to look at now. The motion seemed to indicate that those were filed under seal. So I am wondering if they knew it should be sealed, filed it publicly, left a gap in time, and then it became sealed. Because if it wasn't sealed when the media got it, it's kind of a technicality. Now we're dealing with like the intent of the rule versus the practicality of the rule. I think the core takeaway for me is to be charitable. Maybe they didn't release sealed exhibits. Maybe they released exhibits that were public, knowing that they would later be sealed, but they actually weren't sealed at the time. So like, I'm going to go with the charitable interpretation. But here's my other question. And I'm going to pull that back up because this morning I was in court and I didn't pull it back up to look again. So I'm just going to pull it up right now. But I don't stand by all of my crash out, because if it's gaming the system, it's gaming the system. The intent is fuckery, but maybe not full code red fuckery. You can decide. I just wanted to be as transparent as possible that maybe there's another interpretation of that. However, I maintain that the purpose of this entire motion is not that the defense actually thinks that witnesses are being intimidated. I still think that the intent of this entire motion, because the court's going to be like, yeah, no. I still think the intent of this entire motion is to connect something else in media SEO to witness tampering, witness intimidation ahead of trial. I still think they are trying to bury the stuff about the walk the dog letter. I'm sorry, the what, Emily? It's docket what number?
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
I still think that the purpose of this entire motion is not actually to get the communications. I still think the purpose of this entire motion is to bury the prosecution's allegations that Kouri Richins was telling her mom and brother what to testify to. I still think that's what they're trying to do. I still think there is a clear media strategy. I think we're going to see that media strategy ramp up. Here's the thing. I know that from the outside, some lawyers might look at Alan Jackson and the Reed case, because we know everybody's looking at the Reed case for like the Reed effect. And you all, this is wild speculation on my part. We don't do it often. Draw near. I have to wonder how frustrated Kouri Richins is that, one, when we say KR, we're all thinking of Karen Reed first. Second, I wonder if this defendant is incredibly frustrated that her case is not getting the same kind of attention of other cases. Like, ma'am, this is not Chicago. Like the musical, not the city, but both. And I really wonder if she thinks that she is going to be the most popular defendant on trial for murder. I really do. I really think that she is just like, oh, but no, why am I not? Why am I not the most popular defendant? Why is everybody talking about Brandon Banfield? He's not even tall. I think she's mad about it. My speculation. And I think she wants the type of attention that Karen Reed got. And I bet that in custody, she watched those high profile trials. And I bet she's asking the people that are out of custody to try to get a groundswell of support like Karen Read had. The problem is, A, the facts of this case are exceedingly different from Karen Read. B, you're not going to find a proctor in this case. There isn't one just hiding under a rock in your case. And 3, attorneys who are media savvy in the way that Alan Jackson is are very, very few and far between. And trying to play that game without the history behind it and the amount of media interaction is going to be difficult. Can we please just remember that attorney Alan Jackson was a district attorney in LA County before he was a defense attorney. But let's just go one step further. A, as a prosecutor, he dealt with incredibly high profile prosecutions. And then he became the head of the unit that deals with all of the high profile prosecutions. So if there is someone who has had connections with the media for a lot of their career in incredibly high profile LA cases, which draw a different type of attention than just about anywhere else, except maybe the Southern District of New York, it's Alan Jackson. That is a long running experience with the media that other attorneys can't even fathom, because there's no other way that you're going to gain that kind of firsthand experience dealing with it. And then he also ran for elected district attorney. So he's also done things within politics, and that also requires a level of media savviness and be able to craft a message that is not innate to everyone and takes time and experience. Not to say that these attorneys don't have experience in media cases. They're going to get a crash course on it now between this case and the Robinson case. They're going to get a crash course in it. But you cannot try to be Alan Jackson if you are not Alan Jackson, because there's a whole lot of history there first. So I do not think that trying to run the type of media case that Jackson has or has run is going to work. Also, I think the Summit County Prosecutor's Office runs like 500 felonies a year. So, I mean, I was doing more felony prelims than that in like a quarter. So it's also not the same high volume, and it's different. Also, the Read case had facts that just aren't the facts here. And while there might be some in the media and some in the public that want to rally behind someone accused of quite awful things, we saw that in the Kohberger case. I'm sure we'll see it in the Tepe case. It is different for female defendants. They are not going to have the same level of simps on the internet that a Brian Kohberger has. They will have some. It will not be the same. Ask Sarah Boone. The simping is different. I don't know why. Probably misogyny, sexism, you pick. But there are women who simp on the internet for people like Brian Kohberger and Michael McKee in the Tepe case and others. It's just different. So to try to look at the Read case and be like, why aren't we getting this kind of attention? The Read case is very different. And when you are looking at this case, it's not going to pick up that kind of attention until midway through trial. It's just not. It's not going to have that trajectory until midway through trial. And even with the Read case picked up even more attention after the first mistrial. So I still think we are going to see things that are filed for the media's benefit. And I really think that when a defendant is looking at like, oh my God, why is their case more popular than mine? Which I am guessing happens here. Cases are different. Defendants are different. The internet treats different cases differently. And I really do think that there is always going to be a percentage of people that are looking at a Koberger or a Michael McKee or whoever and are like, but I can save them. But I can change them. And I don't know if you're going to get the same thing for a Kouri Richins where there's a vast amount of people on the internet going, but I can change her. Maybe we will. Maybe we won't. But I imagine for Kouri Richins, if that becomes a thing, it's going to happen after she's convicted. It's just different. It's just different. So I'm interested to see this whatever this is play out, but trying to get the SEO knocked down of like, is Kouri Richins trying to get her family to testify falsely and trying to manipulate witnesses, trying to say, but the prosecution's intimidating witnesses will definitely change the SEO on that topic until the walk the dog letter comes into play in court. So that's my update on that. Trying to give a generous interpretation, even though I am already mad because I thought that this motion was less than ideal. And to be clear, all right, let me pull up docket 1419 before we move on to today's other things. Docket number 1419, it just says attached here to Exhibit A and attached here to Exhibit B. So in the body of the motion, it does not say that they are being filed under seal. So do I think it changes what the goal of the motion is? No. Do I think that it changes whether or not the defense filed something under seal and then gave it to the media? Yes, it does. And what I thought they had done is substantially shadier than this being public and allowing the media to know that it's public. And oh, by the way, it's on the public docket. That's different. Providing something that is public is not the same as providing something to the media that is under seal. It's not the same. So if the defense did not give out sealed documents, I absolutely retract saying that it seemed like that is what had happened. Because to me, looking at the docket, it seemed that that is what had happened. So, fair is fair. And I retract that bit. Do I love the motion? No. But not as shady. Tommy Jude asked, is the walk the dog letter definitely coming in, or is that still going to be decided as the trial progresses? It has to be relevant, but the court has ruled that portions of it can come in. The parts about her sister-in-laws and stuff aren't going to come in. The part about the case will. And it is admissible as it becomes relevant. There's a couple different ways it can become relevant, so I think we'll see it. All right, law nerds, fair is fair. Second matter of business this morning. Let's swoop real quick, and then we got to zoom because I want to get to all of court. Okay, swoop. Second item on the docket. In our Members Only Live, I talked all about an issue I was having with copyright claims on this channel. I did not bring it to the channel at Broad because I was trying to gather more information. And honestly, I was so pissed off about it. I couldn't even talk about it other than to just rant in our Members Only Live because I was so mad. We have some updates, so I wanted to loop everybody in because I think the updates are important. First, we had gotten a whole bunch of copy claims from the Associated Press, and I was beyond furious. Without getting too inside baseball on YouTube, there are multiple content ID systems, one for music, stuff for news media, stuff for creator to creator. And those algorithmic systems, especially in the music space, will automatically grab things without a human ever doing something. The media has access to something similar. And it seems that the Associated Press has been taking court content and putting it into their copyright system, saying, hey, this is mine. The thing is, court content is not theirs. They do not have the copyright in it. No one has the copyright in it. Now, if you use a stream from like NBC, they have copyright on like their logo. And if they have the Olympic rings on it, like the Olympic rings, they own copyright in that. So that can become a thing. But the feed itself does not have copyright in it. They know that. They 100% know that. I am sure that I am not the only one that has had problems with the AP, because it seems that they are putting this stuff in their copy system and just auto-claiming all of it. And then letting those claims linger for like 30 days, which impacts monetization. The thing is, A, EDB can be petty when activated. B, EDB lawyer. C, EDB's been on YouTube a long time. And D, EDB knows a whole fuck ton of people. So I started reaching out to literally everyone that I know. The virtual juror said the Broken Baker has been copy claimed by the AP. Yeah. To anyone who has seen other creators have this issue, here is my update. A, reached out to everybody I could find. I'm sure they all appreciate it. 2, the AP forgets that Neil Monahan, the CEO of YouTube, knows who the law nerds are. Don't fuck with the law nerds. Don't fuck with the law nerds. 3, within the system of YouTube, there is a lot of misunderstanding about how the copy claim system works. So what I learned from the Content ID team, which is a very welcome update, is that when there is a copyright CID claim on a video, there is a 5-day window where the monetization just gets frozen. This is a massive and wonderful update, because what most at YouTube believed is that from the time there's a copyright ID claim to the time it's disputed, that monetization goes to the person claiming it, which sparked a lot of my crashing out. It gets frozen. So when you make a copy claim ID to a 5-day window, or when you dispute it, the monetization just gets held. If you dispute it, the monetization goes into escrow. I still have a lot of questions about the nuance of that, but we'll get there. But the monetization goes into escrow. If you win, you get the monetization back. It can take more than 30 days, especially if you dispute it and they don't release the claims. They always claim these things in like the middle of the freaking night. It's awful. And so the concern for many is that from the time they claim it to the time you dispute it, where does that money go? It just gets held. We know that now. It just gets held. The amount of people that did not know this is a lot. However, we have now found the actual answer with a lot of people. So that's helpful to know that that money gets held, and then it will go into escrow when you dispute it. Also, the AP is going to have a bit of a convo with YouTube about abuses in the CID system, and the fact that if there are abuses in the CID system, they can lose access to the CID system. So this has been escalated because they were continuing to do it. This has been escalated to the fact that the AP is getting called in to the principal's office at YouTube being like, okay, well, you're not going to get to use this system. Creators don't have access to the system I'm talking about. Music does, news media does, and some other do. This is a different type of system that they, as a news organization, have access to. But you can lose access to it with bad behavior. I am not done with this. I will keep you posted. But for now, A, if you dispute within 5 days, creators can get their money back. You've got a window of 5 days. So if you dispute it 24 hours later, you don't lose that first 24 hours of revenue. I still am very curious about how those claims impact the reach of a video, so I am not done with this. Because there's a part of me, and this is just gut part of me, being suspicious. I do not know if this is true. I do not know if this is true. But there is a part of me that wonders if these types of claims hurt the reach of videos. And if it's only legacy media outlets that can leverage these types of claims against creators, and they are leveraging these types of claims against all of the channels covering a thing that they're also covering, it is still anti-competitive. I do not have answers on that. That is the question I'm asking next, because I would like to know. And then we'll figure it out. But I know that they have hit numerous channels, and it has been going on for years. And this last time, I was like, I have time for you now. I did not have time a year ago. I have time for you now. You want my attention? You have my attention. You have my full attention. So there are still questions I'm going to be asking. The monetization issue, I am less stressed about. And I am pissed about the abuses in the system because they know. They know that they don't own that. They know that it's not their content. They know that they don't have copyrights in it. And they're putting it in the system anyway, saying this is ours. It's not yours. Stop it. And they are hitting creator after creator after creator after creator. Stop it. So as long as creators are disputing them, they should get their monetization back because they are going to win their copyright disputes. But making creators linger for 30 days fighting to get their monetization back, creators get paid 30 days after the month anyway. So if you earn revenue in December, you get that revenue in January. But if you have a 30-day dispute, then you're not getting it till February, maybe later, depending on when the cutoff is. The impact for creators could be substantial. And it's bullshit. Not to mention if it suppresses a video or if it somehow messes with the growth of a video. I don't know if it does. But if it does, that impacts how much the video is making first. And then it impacts when your audience sees it second. And then it impacts when you even get paid third. I think it's abusive in the system. And those feeds can't be copyrighted. It's in all of the court orders with a pool camera. Pools are obligated to distribute it to everyone who's part of the pool. You don't own it, bro, and you're not even the pool cameras. Court TV's not doing it. They're the pool cameras distributing the feed. They're not out here claiming people. And the AP didn't even stream this last trial. Ugh. So, I'm glad. It seemed wrong to me that the YouTube system could have that type of monetization abuse in it, but nobody knew that there was a 5-day wait period. It took quite a while getting deep into the CID system team to find that answer out. I'm glad we know it now. I feel better about that. However, you don't get to say this shit's mine when it's not yours. No. So, I will keep you posted. I will keep you posted on that. I am not pleased. And the AP has placed CID claims on my channel, and I have not gotten all of the information back, but I have notes about my responses to them back to 2023. So the thing with ADHD is I had forgotten that until I went to look at my notes about my copy claim responses, and I went, oh. So I'm going to be asking more questions. I wanted to let you guys know where I was at with that. Members, I wanted to let you know where I was at with that. But I wanted to let you guys know this is something I'm keeping an eye on because I do not think it is okay that if someone has the right to that level of access and abuses it, that they still get rights to that level of access. And I'm kind of interested in seeing what happens if they don't. even a little bit of a timeout. Just a timeout. So, funny enough, though the AP has a history of just letting the disputes ride, and if they let it ride, then I win the dispute and then you get the revenue back. All of those disputes have been resolved in my favor, which means they went in and conceded on the back end because I didn't have to wait the 30 days this time. So they went back in and were like, release. So we will continue to see. I imagine those chats with the AP have probably caught some at the AP off guard. I imagine there are very many within the AP that have no idea how their YouTube channels are operating, but they're going to know now. And hopefully they change their practices because you don't own it. Stop it. It's not yours. It's everybody's. We're going to court. So I'm not done. I'll keep you posted. I would still like to know more about how those conversations went. I will find out. And I would still like to know who the fuck thought that this was okay? Who's uploading these to the systems? Who's like, oh, upload it to the system. I get it if it's your news piece, but even if it's your news piece and you're using video for news purposes that you don't own, I just wonder how rampant this is with them. Knock it off, bro. Hopefully your lawyers are looking at everybody going, what are you doing? And I hope those lawyers charge you quite a lot of money to explain to you how copyright works again before this gets more expensive. Because I have time. And ADHD pettiness. See, the thing about ADHD sometimes, let me know if this is you. Sometimes there's just a lot of dopamine in fighting with people. I played water polo for a reason. I was a trial attorney for a reason. I don't like to fight on the internet. I don't. I let so much shit go. I'm not letting this one go. This is going to be content and dopamine. All the way. Just all the way. So I'll keep you posted on how this goes. EDB versus the AP. I would really like news media to just do their jobs well and ethically and neutrally. Really, is it too much to ask? Honestly? I know that more people watch us than y'all anymore. Like, I get it. But maybe it's because we do things differently. Y'all can do things differently too. There's room for all of it. But if you come after creators, A, people aren't going to like it. And B, why? Why? You scared, bro? Come on. I know the creator economy is terrifying. All these people watching creators. There's room for everybody. Y'all just have to figure out what that looks like for you. Good luck. Are we ready to go to court? We got 2 places we need to go to court. Ad commit said, a way to release pent-up aggression. I accept. Look, the law nerd ethos has always been, we'll just build it ourselves. We will continue to just build it ourselves. Also, we will be the iceberg. So if you're going to come crash up on this shit, good luck to you. We're unmovable at this point. It's also why I remind you to have the Law Nerd app. Do y'all remember when we were streaming the Richins case and we got hit midstream and taken off air? Yeah, that was some bullshit. Your reminder to get the Law Nerd app, because when and if anything happens, we will let you know in the Law Nerd app. We've built backups, but that was fucking awful. That's probably the last time I was this mad. Truly. So, Law Nerd app at lawnerdapp.com. There's a whole help section in it and everything if you need anything. We're going to go to 2 different courts We're going to fly real fast. You ready? Emily, we're going to have to go to court so fast today for Charlie Adelson because there are so many updates. Also, yes, quick update in Idaho. If you do not know the TikTok psychic case, put a 1 in the chat. For those of you that do know the TikTok psychic case, just leave it be. I'm going to do the briefest of recitation because we are going to come back to this next week. The TikTok psychic case is a defamation case out of Idaho. Okay, a lot of you aren't familiar with this case. Good, that's really helpful for me so I know what information to give you. If you are ready to be mad about shit, let's fucking go. When the Koberger case first happened in Idaho, when the 4 victims were murdered, there was quite a bit of time there before they arrested Brian Koberger. There was lots of rampant speculation online about this, and there was a content creator on TikTok creating TikToks accusing a professor at the University of Idaho of murdering the 4 students. Also accused the professor of having a relationship with a student and that being the impetus for the murders, that the relationship wouldn't be found out because it is inappropriate. This should not be shocking. It is inappropriate for professors to have intimate relationships with their students. This shouldn't need to be said, right? Like, don't do that. Obviously, don't do that. Don't do that. So the TikToker accused a professor at the university based on their own, this is from court filings, their own clairvoyance and claircognizance, and would not stop. The professor sent cease and desists, multiple. Content creator turned them into toilet paper and was like, The accusations gained quite a substantial amount of media coverage at the time. And from court filings, it seems that the way this all went down is that the TikToker was going through the history department's website and picked a professor. I was like, it's her. After ignoring the cease and desist, the professor sued in federal court in Idaho for defamation. 2 counts. 1 with regard to accusing someone of being a murderer, which is defamation per se. You can't accuse people of crimes. You can. Brendan Banfield, not defamation, convicted, right? Charlie Adelson, convicted. But you can't just accuse people of crimes. And then the other count of defamation per se was regarding the workplace inappropriate relationship with a student. The TikTok creator decided to represent themselves. And so that's gone about as well as you can think that it would go. The professor won a motion for summary judgment on the issue of liability. So it has been found by the court that the TikToker defamed the professor. Emily, you're not using their names. No. I don't want the TikToker's name to be in the transcripts of this video or connected to it. No. No attention for you. The professor won on the issue of liability. It is now set for trial on the issue of damages. It goes to trial the exact same day that Kouri Richins has opening statements. I know. And it's federal court, so it's not going to be streamed or anything. The TikTok creator has stated that the court is impeding her practice of religion because the court has said things like, do you have objective evidence as a defense? And she has said things like, my tarot card readings, not objective evidence for court. My clairvoyance, not objective evidence for court. At one time, she referred to herself as a spiritual witness to the crime. Yes, that actually happened. I am not joking. And this has just gone around and around and around and around and around with the, but Your Honor, not intentionally, but Your Honor, it's true. But Your Honor, the professor didn't prove that it's not true. But Your Honor, and around and around and around and around. At one point, the lawyer for the professor called this a clout circus, and it's one of my favorite things I've ever seen in a legal filing. And it pissed off the TikToker. The court has been more patient than I think I've ever seen a federal judge. And the motions that have been thrown the direction of the court seem to have been difficult for the court to deal with, in that courts are used to dealing with attorneys. And attorneys, shockingly, generally follow process. There's an order of things. The TikToker, representing themselves, just kind of throws things at the wall randomly, and everybody's like, what the fuck are you doing? That's not how that works. Crazy. So today, there was a pretrial conference about this case because it's going to trial this month, in person in Boise. Or Boise. I always say it with a Z. I say Disney with a Z. It is just EDB. Going to trial in federal court in Boise. TikToker is representing herself. TikToker today, and we will get to this next week, today filed a new motion to dismiss. And on the hearing today, told the court that she would be filing a motion for continuance. Sweet and Salty said, can we be there? I can't be there. And federal court doesn't allow for streaming. But I'm going to put in an order to buy the transcripts. I'm not sure this is going to go to trial. I'm still not sure. So the TikToker told the court today that she'll be filing for continuance. And the court was just like, I am not prejudging your motion for continuance, but there would need to be exceptional circumstances because this trial has been on the books for quite a long time. And keep in mind that TikToker has a fee waiver for everything. So all the filings, she's the defendant. All the filings she's filing, she has a fee waiver on. She has a fee waiver to deal with PACER and to get the documents for everything. But the professor has to pay for the lawyers, has to pay for the lawyers' time, is paying for lawyers to respond to motions that you wouldn't even have to respond to if the other side was also a lawyer. The attorney for the professor said repeatedly that the TikToker is not responding to their emails, so they can't meet and confer. The TikToker interrupted the court in this hearing and said, I responded to that email, singular, one. The court told all the attorneys and the pro per, that they needed to discuss the exhibits because generally, especially in federal court, you agree to the admissibility of the exhibits beforehand, and then you argue admissibility, hearsay, and the rest of it, and you agree to foundation. And she's like, I'm not agreeing to that. And the court's like, it is strongly encouraged in this court that the parties meet to deal with issues of foundation. That does not mean that you waive your rights to argue other factors of admissibility like relevance, but it does impact how smoothly the trial goes. So at the extended hearing this morning, this would have been a 10-minute hearing, but at the extended hearing this morning, the court was explaining how trial procedure worked, what voir dire is, explained like 4 times that you cannot talk to the jurors. I think the court's concerned. My notes a couple times say, oh, the court's worried. Yeah, I'd be worried too, Your Honor. Talked about how you can't talk to the jurors, and that includes like in the hallways and in elevators. And then the court went the extra length to say, and when you get the list of jurors, because both parties get the list of juror names, the court went over in excruciating detail how not to contact the jurors on social media, on DM, on requesting access to a Facebook page if you need to friend them. That you can only look at what's publicly available about the jurors. You cannot contact them when you got the juror list. Honestly, if I was a juror in Boise, I wouldn't want my name and information given to this defendant. However, so the TikToker has filed a new motion to dismiss, arguing jurisdiction. We'll get to it next week because now the plaintiff's attorney is like, Your Honor, this motion is kind of out of order. This motion was argued and litigated like 2.5 years ago. But we're now on an expedited filing schedule. And these attorneys already have their work for the next few weeks laid out. And the court's like, I'm going to need a response early next week because we need to rule on this before trial. And the plaintiff's attorney is just like, because they have depositions and all this stuff going on in all their other cases. And they still have to pay for their witnesses to travel because this is normally in the Coeur d'Alene court. And a lot of the witnesses are where? Moscow. And now you have to get the witnesses that you need from Moscow down to Boise. What, 3+ hours away? And you have to pay for those witnesses. I'm sure some of the witnesses are like, fuck this shit, I ride. But still, this is hugely inconvenient for the professor and continues to be. But they're going to trial. And then all of you are saying more like 5 hours. Not close. And then the court is talking about the motion to dismiss and saying that this is the kind of thing that's normally litigated more in advance, but it's going to need to be on an expedited schedule. And the TikToker says, well, I'm also going to be filing my motion for continuance. And then says, well, I mean, I'm out of the country, so. What? I'm out of the country, so. Y'all, I still don't think she's showing up. I don't think she's showing up. I really don't. I don't think she's going to show up. There is another hearing on this case in person before the trial. I do not think she's going to show up. I really don't. And I think we will see that in the motion to continue. When we have the motion to continue, I'll ask, but the court was just like, what are we going to do about the trial? And she's like, well, Your Honor, it's going to depend on your ruling. He's not dismissing this based on jurisdiction. That ship has fucking sailed. I don't think that she's going to show up for trial. Maybe she will. But I just wonder if the court is going to hold this trial in absentia where she just doesn't show up. A jury is going to grant damages of some amount, and they're going to have to try to attach her assets out of the country, which I'm not going to comment on further because I don't want to give anybody any ideas. A lot of you are saying, can they arrest her for failure to appear? Not outside the jurisdiction. And you can't extradite people for civil cases. And I truly don't want to talk about that more because I don't want to put that I'm not putting that information out there. It is ill-advised to not show up in court. It is ill-advised. It is ill-advised to not show up in court. So we will see. And I'm still not sure that in this civil case, we're going to see the defendant and their lawyer show up. I will be surprised if they show up. So we'll see. And I can understand why the plaintiff, the professor, is nervous that this isn't going to go well. And even if they do win, if they'll ever be able to recover. So she said to the court, I'm just going to have to wait and see what your ruling is before I make travel arrangements. It's not getting dismissed. It's not getting delayed. And I imagine there is going to be some last minute bullshit of, I can't even get there. So I'm keeping an eye on it. We'll get to those motions later. I didn't have the patience for this level of bullshit today. I can only imagine how frustrated everyone is and the injustice of like, whatever, you ruin somebody's life, reputation, you forever connect them to this horrific case that impacted the entire community. The media has completely, other than a few of us on YouTube, the media has completely stopped covering this. Even when the professor won summary judgment, it was not covered anywhere. It's connected on Google forever. And the amount of emotional distress that being kind of hate brigaded the way that the professor was when this happened is wild. Also, the professor didn't do anything to put themselves into a public forum. They were doing their job, and somebody went to the website of their job and decided them. And in the damages conversations, the professor talked about the stress, the fear, the depression, the death threats, the threats on the voicemail at work, people calling the university, asking for the professor to be removed from the university, calling everyone in the department. And then also, if it's you, right? You do your job, you go to work, and somebody goes sideways on you. And then the entirety of the internet, or it feels like the entirety of the internet, goes after you, your coworkers, your family members, the people that go to the university, your bosses that are bosses of bosses that don't even know who the fuck you are, but now do. The amount of stress and also the level of like mortified of like, I had nothing to do with this and I am so sorry. Like, there is now a shit show going on at your university at the same time that the university community is dealing with the death of 4 students. The university stood behind the professor. But can you imagine? I can. And I'm sure that's even just a small percentage of how awful this would be. And of course she had to go through trial on it to clear her name. But I'm just so frustrated on behalf of the professor. It is not easy to deal with defamation like this. It's so frustrating. And to be thrust into the public sphere because somebody decides to talk about it on TikTok and it goes viral. It's awful. The TikToker is no longer on TikTok. I don't know if the TikToker is on other socials. If they are, I don't want to know because I don't even want to click because I don't want that to have clicks, views, traction in the algorithm, anything. It sucks. I'm glad that the university stood by them, but it sucks. So it's going to trial. It's going to trial. The Lauren, I don't know if I think the harassment probably stopped. I'm sure no one that harassed this professor ever apologized, but the TikToker kept saying that Kohberger was hired by the professor. So even though Kohberger's pled guilty, the TikToker still maintains that she was right. And the judge today was very carefully trying to explain that none of that can come up in this trial. None of it. But also, what are you going to do? Sanction her when she invariably says things in front of the jury if she shows up? Invariably says things to the jury that are inappropriate? What are you going to do? Honestly. Take her law license? Disconnect her from ChatGPT or whatever she's using? I don't know. The judge has been very mindful. We will see how this goes. So I'm keeping an eye. We will talk about it, but it's going to go to trial at the exact same time that Kouri Richins does. If it goes to trial, and we'll see how it goes to trial. I just feel so bad because when you're in that position as the plaintiff, you send a bunch of cease and desist and somebody's like, no, fuck you, I'll call you what I want, and try to ruin your professional reputation. Also, as if academia is always so forgiving. I'm sure there will be some universities that even if this professor wanted to move, there will be some universities that'll be like, I don't want to deal with that. I don't want to deal with it. That's a lot of baggage. They might be great. That's a lot of baggage. So it is going to be detrimental going forward. And that fucking sucks. But what do? You send the cease and desists. It's not responded to. It's mocked. It doesn't stop. You either then have to say, I'll just let it go forever, or you have to sue. This lawsuit was filed just as a refresh. And for all of you who aren't familiar with this case, let me just pull up the exact date because I always forget because it's literally been that long. This case was, this case was originally filed December 21st, 2022. December 2022. And it won at summary judgment. So, the real world fallout from stuff like this is frustrating. So we'll see what the court does. I know a lot of you are like, how can it have been that long already? I know. And I agree with you. Really frustrating. All right. So with that, we are going to zoom from Idaho and go from there. Miss Casey Miller, no. Asked, is there anything that can change this from a civil case to a criminal case? No. Not on these facts. I mean, I guess if the TikToker showed up in court and like punched the plaintiff in the face, then I mean, you could have like an assault and battery case, but it's defamation. So not on the facts now. If something, I mean, there's always the possibility that something new can happen, but no, not on the facts here. And it sucks because people feel like they're untouchable. And that sucks. So we're going to keep covering it as best we can. We will, if it goes to trial, get the transcripts as best we can. If anyone's in Boise and happens to want to go to the federal court, courtroom 3, we can talk about what going to federal court looks like. Bring pen and paper. They don't allow any electronics. They'll check your glasses to make sure they can't record. They'll make sure that they are not like Facebook Meta Ray-Bans or whatever. They'll take your Apple Watch. Federal court's like no electronics. All right. Are we ready to go? Lindsay in the chat, I see your question. I do not want to answer that on the internet. I do not want to help. I'm not helping anyone here. So that I see your question, but that's why I'm not answering it. Because I am not going to unintentionally give legal advice to bad actors in this case. And I don't want anyone to feel emboldened. I am not sure she's going to show up in court. there can be pretty serious consequences for that. We're going to leave it there. And you never know, maybe she'll show up and go to trial. Who knows? We can always hope. You guys ready to go to Tallahassee? Ready to go to Tallahassee? Sure. Great. Let's go. Let's talk about Charlie Adelson, everybody. We talked about this yesterday, and there are some other court hearings that happened this week that I want to catch up on. But today we are going to go somewhere we rarely go. We don't do this a lot. We're going to appellate court. I think we should just show up and play pickleball with LYK while we're all there and then ask for lunch. It's like, hey, the law nerds are here. Can we play pickleball and have lunch? We're going to the appellate court. Charlie Adelson wants a new trial. And because we are seeing these motions play out in Utah on change of venue, on what's going on with the jury, the full thrust of these appellate arguments are regarding the denial of the motion to change venue. Donna Adelson used a lot of energy arguing over this as well. Charlie Adelson was convicted of the same thing Donna Adelson was. I know a lot of you watched the trial. We did not watch the trial together. But God, we heard enough from Charlie Adelson and all of those freaking calls. The man wasn't even on trial, and I was sick of his voice in those calls. And then the surreptitious recorded meeting with Catherine McBanoel when he's just like, right. So now that we are getting to the appellate court, we are seeing just the lawyers arguing about the motion for change of venue. Remember that appellate court works a little differently than what you see in your state level trial courts. They only review the record. They're not going to go watch it back on YouTube. They read the record. Emily, that's like tens of thousands of pages. It is. Oh yeah, no, Charlie Adelson was a full baby, I love you. Not as much, but there was some of it. It was more like, baby, I want to see those boobs. It was really more about that for him. Baby, I love my cars. Show me your boobs. That was really more with Charlie Adelson. And he was joking about paying for, just one of them, if I remember. Misbehaving in the chat said, no, it's baby, I love me. Yeah, it really is, right? So we're going to go to the appellate court. We are going to take a look at the arguments. The thing I appreciate about the appellate court is that they really do just pepper the lawyers with questions. The appellate court is just like, what about this? And what about that? And what about this? And what about that? And they jump in and ask pointed questions of both sides. Do not think that just because the appellate court is asking a lot of questions of one attorney, it means that they are not on their side. Appellate court, and I don't know what law school's like anymore. I mean, I don't know what law school's like anymore. But this was more like my experience in law school when you're trying to say something and your professor's like, excuse me, but what about this? And what about that? And it is a way of challenging your thinking that is not how we discuss things socially, though lawyers still sometimes do. So it is a whole different vibe than you would see in state level court. And there are times I will say this judge operates almost more like a federal judge or an appellate judge. And I appreciate that when the judge is like, yes, you're doing this. I'm with you on this. Answer this. Love it. So for those of you who haven't watched appellate proceedings, you will notice that they are more formal and that they do interrupt the lawyers. I love that. I love seeing what the judge's questions are. We did not read the motions. We did not read the filing papers. A good attorney will be able to bring us up to speed on what their argument is very quickly. So I'm optimistic that that will happen here. Fingers crossed. And we'll all get to enjoy it together. So we are going to go to court. This hearing was, let's see. This was Tuesday. Let's see. We're going to do our new trial motion. This was on Tuesday. And we'll take a look. You will see that Charlie Adelson is not there in court. This is just the lawyers arguing. And this can take months for the appellate court to decide. At some point, we will circle back to Charlie Adelson's appeals. I'm still very curious about some of the things here, but because we did not watch the trial, it's nice to be able to take a step back and watch this. I imagine Charlie's arguments on change of venue are very similar to what Donna Adelson argued, right? Everybody in Tallahassee knows about this case. Everybody in Tallahassee thinks that we're murderers. We can't get a fair trial. Like the same thing Kouri Richins saying, right? That's what those arguments are. So we will see. And we're going to be back in the Supreme Court of South Carolina next week for Murdaugh looking at his new trial appeal. So right now we are in the Florida First District Court of Appeal. That's who's going to handle Charlie's appeal. That's who's handling Donna's appeal. That's not who's handling Sarah Boone's appeal. Sarah Boone's in a different court for that. She has a different district for appeal. In fact, her brief is due pretty soon if she didn't lose another lawyer. So we'll see. So let's go to Florida. It's probably warmer than it is here in Middle Tennessee because it's not warm at all in Middle Tennessee right now. So hopefully it's warmer for y'all. And we're going to zoom a little bit. This is the courthouse. Looks kind of similar to the appellate court we saw in Massachusetts. There's a lot of downtime of people just like chilling. So we're going to zoom before the lawyers get started. And we hear argument for the Court of Appeal here in the First District of Florida. So let me make sure we get our closed captioning on. The closed captioning that I like.
Authorized media, no cell phone usage, no cell phone videos or pictures in the courtroom.
Reminding everybody what to do. Once they're at the mics, I hope we lose some of this background feed, but we'll see. And we'll get to see the attorneys argue, and then we will get to see the judges ask them questions. It's kind of cold in Florida. Yeah, the appeals courts are gorgeous. The chambers of the judges are gorgeous. It's a whole different thing. It's cold in Florida. That's cold for y'all. That is. Also, because Florida, there's like a whole range of,
All right.
of temperatures.
First District Court of Appeal is now in session. All who have this before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Okay, other than no hear ye's, wait a second. Draw near and ye shall be heard? Florida. It's giving Massachusetts. I love it. Other than no hear ye's, we have a very formal call to order. I love it. I love it so much. Okay, pretend it's hear ye, hear ye. Draw near and ye shall be heard makes me so happy. It just does. I like the formality. Maybe when you start court with hear ye, hear ye, hear ye, all of those appearing before the court, maybe if you start court that way, it'll remind the attorneys that chewing gum in court is forbidden. Like, we can't lose all the formality. I get it. Like, you know, pajama pants are pants again that you wear in public. I'm not mad at that. Court should still have, for me, a level of formality. It just should. It's appropriate. Maybe I'm just old. All right, let me make sure, because I moved things around on this. Let me just make sure we've got the same view on both. And we are going to get to court. But I love the draw near and ye shall be heard. We're going to listen to that one more time.
Rise.
Ooh,
First District Court of Appeal is now in session. All who have this before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Draw near and ye shall be heard.
Please be seated.
All right.
Good morning and welcome to the First District Court of Appeal. We have one case on the docket today, Charles Adelson versus State of Florida. Counsel, when you're ready, you may proceed.
All right, Your Honor. Good morning.
Good morning. May it please the court, Michael Luffman on behalf of the appellant, Charlie Adelson. Seated with me at counsel table is co-counsel Laurel Cornell-Niles. I'd like to reserve 5 minutes of my time for rebuttal.
So noted.
Very formal.
I'm hoping to focus the beginning of my time this morning on the first two claims, which are the jury selection.
Emily, we didn't even get into his intro before pausing. Tricia said, why is there no Georgia? Tricia, this is a fantastic question. Georgia Kappelman is not involved in this at all. The state of Florida will be represented by somebody from the state's attorney's office that handles the appeals. Some district attorney's office will handle their appeals, most won't. Normally in the criminal process, it'll go through the state level courts, and the district attorney's office does not have appellate lawyers. That then goes to the state attorney's office, not the U.S. attorney's office, the state attorney's office, and they have the appellate lawyers and they handle appeals on behalf of all of the trial courts in the state. Most jurisdictions go that way. Some jurisdictions don't. Georgia Kappelman is a trial attorney. She probably has a whole bunch of other cases on her desk. She does not have time, bandwidth, expertise in doing appellate work. It's a whole different world. Standing up and doing a murder trial versus doing a murder trial appeal, whole different world. However, you will often see that the appellate counsel for the state will talk to the prosecutor if need be. But remember, everything's on the record. So the attorneys just rely on the record. So they don't always need the input from the trial attorney. So it goes to a totally different attorney. Appellate work is a completely different skill set. And it's a lot of writing. And that is not always what the trial attorneys want to do. They're like, give me another trial. Y'all do what you're going to do on your briefs. Tab them appropriately.
Claims.
Great
I think
question.
they're intertwined. And then I also intend to briefly address ground 3. So let me begin with the jury selection claims. Claim 1 concerns the trial court's failure to grant the motion for a change of venue. Claim 2 concerns the trial court's failure to strike the panel, and then specifically, as that issue evolved, to strike the middle group of jurors, jurors 51 through 102.
When he says strike the panel, he means he wanted the court to yeet all the jurors on that panel. Yeet. All of them.
For reasons that I'll get into in a second.
I'm curious what
Let me
those
begin with the
reasons
change of
are.
venue argument. The numbers in this case are pretty striking. We know that of the 130 jurors who were...
Excuse me, Kouri, you've got like 1,500. They had 130. They had 130 and they found a jury. It can be done. I'm going to move these down just a little bit.
questioned individually, and that's the way this process went. The judge began jury selection by individually questioning jurors in groups of 50. There
It's a
were
lot of
3 total
people.
groups that were ultimately questioned to determine whether or not they've formed an opinion about the case and whether or not they've been exposed to pretrial publicity. Of the 130 that were questioned, 54 said that they had formed an opinion regarding innocence or guilt, and 53 of those had formed the opinion that my client was guilty.
And they
Not wrong, though. Like, not wrong, though. Out of 130, 53 jurors said, yeah, I heard about the case. Your dude did it. That still leaves a substantial amount of jurors that hadn't.
Questioned, 54 said that they had formed an opinion regarding innocence or guilt, and 53 of those had formed the opinion that my client was guilty.
And they were excused for cause,
They all
correct?
were.
All right, so let's start a little bit about the
This is the
procedure
court.
that the rules require before.
Oh, I moved this wrong. Did you see his face? Did you see his face? Let's talk about procedure. And he went, Oh boy. Oh boy, counsel.
Those interview questions are even asked. Why don't you address, the rule requires a written motion, an affidavit, and a good faith statement, correct?
Yes, Your Honor.
All right, and that didn't happen here.
No, Your Honor.
And
no.
what type of things would we have seen in an affidavit before any jurors were interviewed?
I don't know. And my response to that,
Isn't that the problem? It requires an affidavit. What would have been in the affidavit? Well, I don't know, because we didn't do one. Counsel, if there are 3 things that are needed, you didn't do them, it's going to be a problem. It's going to be a big problem. It's going to be a big problem.
is, and I understand that I'm attacking the rule and it's a requirement, although there's certainly case law that says that if a motion in any context is made orally, and if there's a component within our criminal procedure rules that requires it to be written, if it would be a useless gesture for such a motion to be submitted in writing when it's been thoroughly discussed and ruled upon orally, then that's not required. And I think that, again, specifically applies to this type of case. We know the Florida Supreme Court has been very clear that change of venue claims almost always need to be considered during jury selection.
Yes.
That a judge is not going to grant a change of venue claim pre-trial.
Yes.
Sure, but one of your arguments is that the Tallahassee community, almost 300,000 people, was so tainted by what you characterize as pervasive media that there could be no jury selected that would be impartial. And wouldn't affidavits have shown, for instance, that what types of media that the citizens of Tallahassee and this community were consuming? And you definitely see in the record the local sources, national sources. You make the argument that this isn't like the 1994 trial of Danny Rawling in 1994, where people would watch Dan Rather or Tom Brokaw. And I think that's right. But wouldn't the affidavits also have shown that maybe consumers curate their media differently?
Yes.
We saw in this transcript there were many consumers of media who said, I'll give some examples. They don't watch television. I turned off my propaganda box 3 years ago. I don't read the...
Oh, those jury affidavits must have been feisty. Because yes, the appellate court has the entire record, and the appellate court would be looking at all of the jury affidavits. And the appellate court is like, yeah, well, your jurors aren't watching TV. Your jurors aren't watching TV. They're not. They're consuming media in other more curated ways. Correct. I told you guys, through the entirety of the Depp v. Heard case, Dr. B saw nothing about it. It's just not in his algorithm. So yeah, I'm not surprised that the jurors are like, nah. The Tallahassee jurors, I turned off my propaganda box. That's funny. I love that the court's highlighting some of these from the affidavits. I love it. People have tailored what they want to watch. Yeah. I mean, I think the last time, other than Traders, because I love Traders, I think the last time that I actually wanted to watch anything in real time that wasn't like, I don't know, the Olympics, and even then, was probably Game of Thrones, because I didn't want spoilers for my coworkers, because we were all watching it at the same time, so we were all talking about it. Like, of things I've actually watched on my TV in real time, that might have been the last one that wasn't sports, that I was like, if I do not see this tonight, I will not be okay. Other than Traders. You guys let me know. What are you like, I have to see this in real time? Let me know. If anything. Continuing on.
Paper. That's for wrapping mullet.
I'm sorry. The next answer was, I don't read the newspaper. That's for wrapping mullet. Okay.
I'll give some examples. They don't watch television. I turned off my propaganda box 3 years ago. I don't read the paper. That's for wrapping mullet. Very rarely do I watch the news. And so you see a lot of behavior in this typical kind of Tallahassee
Oh my God,
community that's
that's for
different than
fish.
1994. Couldn't you have shown those things in an affidavit before you interviewed a single juror?
I mean, clearly, the
That's
rule
for fish.
says that should have been done, and I'm not disputing that it should have been done, but I submit that it was established by the record as you just indicated. The record very clearly shows the way that the 130 jurors that we're talking about consumed their information about this case. And it's not just, contrary to what happened in 1994, what was happening in the 90s, it's not just the print media. Clearly, the Tallahassee Democrat covered this case extensively. It's not just the local news. Clearly, the local news covered this case extensively. But unlike the 90s, now we have several jurors saying that they're getting their information from cable news networks, court TV shows.
YouTube, Court TV, 2020, Over My
YouTube.
Dead Body podcast, Preston Scott Show, Tallahassee Democrat. But what you don't have in this record is how many times
Go
those
YouTube.
exposures happened, whether they were biased or not, whether there were some broadcasts or podcasts that, in fact, argued that your client.
Oh, I wouldn't have come up in this. I was not covering the Charlie Adelson case before it went to trial. We were not covering it. I'm sure we have come up in Richins because we've covered it from the beginning. I would be surprised if we didn't. I have had DA friends in LA reach out to me when they talk about what they watch regarding courts and cases, bring up my name and bring up our show. But I'm not surprised that you're hearing the jurors say, I watch YouTube, I listen to podcasts, I do not watch traditional news.
Was innocent.
I
stepped on the court's point. It was a good point.
Happened, whether they were biased or not, whether there were some broadcasts or podcasts that, in fact, argued that your client was innocent. We don't have the content of that to show how that would have influenced the veneer, correct?
We do not have that from affidavits pre-trial showing the things that you just mentioned, but we do have that in the record based on the answers that the jurors gave. And again, when we are talking about a little over 40%, that's a huge number. In the Murphy case, I believe it was.
What's 40% matter if you can still find 12 jurors to deliberate? Honestly, there's no bright line on this. The rule is, can you get a fair trial? Can you get a fair trial? That's the rule.
Right around 25%. And in that case, the court said that's not enough. Here we are at 40%. So when you talk about 40%, when you talk about the judge making a finding when granting the protective order pre-trial that Tallahassee is in fact a small community, when you talk about this case has been permeating Tallahassee media sources for almost a decade at the time of this trial, when you talk about there was 3 previous prosecutions, one of which resulted in a mistrial and a subsequent trial just a year before my client's trial.
Sure, but why don't we talk about what
Crime with less people, less trials. Crime with less people. His mom made the same arguments.
the Florida Supreme Court says when there's pervasive media. Certainly, no one would argue that there wasn't pervasive media in the Danny Rowland case, right?
Correct.
We're talking about 5 murders, college town, again, maybe a small community as you would describe it, perhaps.
Sure.
So with that, since that case, in the Ellerby case, the Armstrong case, the court has said that it's not enough to show that media was pervasive. It was, could the juror be impartial? Every single juror seated in this case said that no matter what contact, many of them had no contact with media or information, that they could be impartial. Isn't that right?
Counsel, they were using the newspaper with your client's face on it to wrap fish. They didn't care.
That's correct.
All right, so specifically, I'd like you to address the Armstrong case. The state raised it in the answer brief, and you did not address it in your reply brief.
Oh, boy.
The Armstrong case, the Florida Supreme Court, and this is 24 years after the Manning case that you cited in your case, they said that if you don't renew your objection to the jury before the jury is impaneled, in fact, your client accepted this jury, that you have waived.
Oh, boy. Remember when we talk about use it or lose it? This is how that plays out down the road. You have to preserve the issue.
your case, they said that if you don't renew your objection to the jury before the jury is impaneled, in fact, your client accepted this jury, that you have waived it and we may not reach that issue. What do
Wow.
we do with Armstrong?
So two responses to that, three actually. Just quickly regarding my client accepting it, I don't know that my client accepting it matters much. I think the concern is did defense counsel renew the objection? The state made an issue out of that. And if you look at the question asked of my client at the conclusion of jury selection, the judge literally says, you have no choice but to accept because you have no strikes left.
But
do
was
you
there an
accept?
objection?
There needs to be an
Was there-
objection.
I understand. But again, so that I'm just responding to the concern. I understand the state raised it, and that's probably why you're saying it. But my client accepting the jury is irrelevant to this matter. The question is, did defense counsel renew the objection? I acknowledge that generally is what's required for any type of jury selection.
Did it happen? You've said a lot of words. You've said a lot of words, but you know what you haven't said? If the objection was renewed. I suspect it wasn't. But was the objection renewed?
Claim. However, Manning is specifically a case where we know from the dissenting opinion the request
Words,
to change
counsel.
venue was not renewed.
But
We know-
I'm going to repeat, Manning was decided 24 years before Armstrong in 2003, where the Supreme Court specifically said the failure to renew is waiver of the claim.
I understand.
That's precedent that's
That's
binding on this
precedent.
court, is it not?
The court doesn't.
Is it binding precedent? Yes, it is. Yes, it is. Is it binding precedent? Yes. You still didn't answer.
We're all familiar with the principle that a court doesn't overrule itself sub silencio. The court has not specifically said.
While I love that you dropped sub silencio in there, counsel, what you haven't said is yes or no. You're just filibustering. You're just filibustering.
To renew is waiver of the claim.
I understand.
That's precedent that's binding on this court, is it not?
I had to back up. So much
the court
filibustering.
We're all familiar with the principle that a court doesn't overrule itself sub silencio. The court has not specifically said Manning's no longer good law. That being said, I rely upon Manning because it was ultimately reached consistent with what I think the U.S. Supreme Court has said is an appellate court's burden to go through the record in one of these cases to determine if there's a change of venue issue. But beyond that, I will acknowledge that at the very least, to the extent that this court finds that it's not preserved because it was not renewed, then the question is it fundamental error? And I submit that based on the facts of this case, we do.
He did concede that it wasn't preserved in the middle of the word salad there, just in case it got lost in all of the things that he said. But he acknowledged that it might not have been preserved, but that's going to be okay. All of you are asking if I have this on 1.25 speed. I do not. This is on normal speed. Remember, appellate arguments are very carefully timed.
Meet the fundamental error standard. In the Smith case just 4 years ago, the Florida Supreme Court specifically said that the failure to preserve a change of venue claim can nevertheless be reviewed under the fundamental
Well, my
error
understanding is, the reason we have this
Tag
very, very
team, back
unusual
again.
requirement
Check
for,
it, direct it.
a
Let's begin.
renewal of an objection
A new judge is tapped in.
is not just simply, it's not just Simon says, just, you got to do it twice or else. It's that it is possible that the defense is happy with the jury. It's generally in the challenge context when you challenge a juror and they want to see whether you renew that challenge, that you are in fact satisfied with the jury. So I don't know if you can say that it's a fundamental error issue if in fact the defense was satisfied with the issue. Now, I did believe when I saw Armstrong, it's like, wait a minute, it's not what happened in Joyner. It's not a cause challenge, it's change of venue.
Correct.
But when you read Armstrong, it's very clear. First of all, it says that a change of venue motion is premature
Agreed.
until you actually attempt to select a jury. What
Correct.
that says
Agreed.
to me is a change of venue.
I think that should be the rule in every jurisdiction. I do. It's the thing that makes the most sense. I think it should be the rule in every jurisdiction. And what they are talking about is you don't really know if a jury pool is tainted until you have the people in and you start talking to them. If you start talking to your jurors and every single juror is like, that dude is guilty, then you've got a problem. Then you might need to change venue. Then you might not be able to seat a jury pool. But you can't know that out of the ether before you start trying to pick a jury. Because especially when you have individuals who have such different interaction with media. And this continues to change. It is going to, I think, be easier to find jurors who might have never heard of a case. And then if you find jurors that have heard of a case, it might become more likely that those jurors have heard a lot about a case. So it actually might become more distinct that you're not going to have as many jurors who have kind of heard of a thing. You're going to have a lot more jurors that either know or they don't, because media is so fragmented and people are able to curate it more. And I can understand why people are going to curate it and be like, look, I just want to watch videos with animals. If my Instagram, if there's no 4 legs, I don't want to hear about it. I don't want to hear about it. Leave me alone. 4 legs or nothing. Don't at me in the chat about wyverns. We can have that conversation later. But your media feed can be curated to you. And then if you do know about a case and you know a lot, you just get yeeted. Fine. So it might actually get easier. And I appreciate what they're saying is what the court is asking this attorney is, look, if you can't do this before jury selection and you made the objection before jury selection and then you start selecting a jury, maybe you find a whole bunch of jurors that you're satisfied with. So if you don't renew the objection, how does the court or the appellate court know that this is still a problem? Because maybe once you get into jury selection, you're like, actually, I like these 12 people. Let's ride. You 12, you're with me. Let's go. I like these jurors. And so renewing the objection means that the lawyer is saying, I concede that I have to pick a jury and the court is making me pick a jury, but I still don't think these 12 can be fair. That's what the court is trying to get at. How do we know?
Is a jury selection issue.
Sure.
And what I draw from that is that, just as Judge Rowe is saying, if you in fact are able to find jurors who swear that they are untainted, then I don't know if there is in fact a change of jury issue. It very well may be that the defense thinks, okay, I found untainted jurors. I don't really have any reason to continue with the change of venue objection. So that raises 2 things. Number one, whether the fact that you have untainted jurors overcomes the fact that the community may have had a low level of taint. And number 2, the suggestion that it's fundamental error when the whole point of the objection is that the defendant is satisfied, which I don't think a fundamental or claim can overcome.
So a couple of responses to that. Again, the Smith case is 2021, and it's specifically page 28 of the Florida Supreme Court's opinion, and they clearly went on to address the claim for the change of venue motion, despite the fact that it was not preserved, and they did so under the fundamental error standard. And so, I'll quote from the case.
But isn't there a difference between preservation and waiver?
Sure. Well, yes. But so if we're going to waiver, and now if you're addressing what my client said.
He chuckled. He's like, oh, that, Your Honor. That.
At the conclusion of jury selection, that's no waiver on my client's part when the judge specifically told him, you have no choice.
I guess perhaps I should just read Armstrong again, because Armstrong says a motion for change of venue should be renewed at the conclusion.
It's never good when the jurist on the bench is like, perhaps I should reread that case. They're not wrong, counsel. They think you're wrong. And yes, of course, appellate judges can be wrong. However, it's going to take another court to tell them that they're wrong, because they're not going to think that. You're going to have to go to a different court. And the other court's going to have to say, nah, you're wrong. Maybe I have to read Armstrong again. Not good. Not good.
Of jury selection or be considered waived. So it is the failure.
She is reading directly from the case that she is citing. Maybe I should reread this. Counsel, does this not say what the fuck I just said it said? Enlighten me.
Again, because Armstrong says a motion for change of venue should be renewed at the conclusion of jury selection or be considered waived. So it is the failure to object that is the waiver in this context.
Oh boy.
I mean, do you read it any differently than I do?
If that were the case, then Smith.
Your Honor, you continue to read that correctly.
In 2021 would be wrong. And Smith obviously is more current and specifically says that because the issue was not preserved, because it was not renewed at the conclusion of the jury selection proceeding, we review this claim for fundamental error. So I submit to you, again, this court has the ability to review the claim. Smith from the Florida Supreme Court very recently has said for at least a change of venue claim. It may be different for a peremptory challenge, the failure to grant a cause challenge, but when it comes to change of venue, the Florida Supreme Court has specifically said it can be reviewed for fundamental error. And I guess going back to Manning, and I understand the time difference, but Manning would be a great example of that. You literally have the attorney in Manning saying at the conclusion of jury selection, I believe we picked a fair and impartial jury. And I submit that there's no jurist in this state that would review the facts and reach a conclusion, unlike what the Florida Supreme Court did, that there's no way that venue could have been fair within Columbia County in that case. So that's exactly why these claims can still be reviewed for fundamental error.
Just generally speaking, normally when we talk fundamental error, it's because that an error wasn't preserved below. Can
Correct.
Fundamental error be affirmatively waived?
Oh boy.
If defense counsel had said, if the question rather than to Mr. Adelson, do you accept this jury? And let me point out, you have no choice but to accept the jury, but answer me anyways, do you accept this jury? If it had been defense counsel, you previously raised some objections. Do you now no longer renew those objections and accept this jury? If
there
that
an
would be the
answer?
case, I would have no ability to make an argument in front of you today.
Oh,
that
so
would be
yes.
waiver. That's not at all what we have in this record. I think the
Well, it
fact.
sounds to me like you're going up a 3850 Avenue, but let me ask you this question. Is Arms
Hey, counsel, it feels like you're barking up a whole different tree here. Counsel, that's what are we doing?
Armstrong's a 3850 appeal?
Correct.
The other cases we're talking about earlier were direct appeals. Is
Correct.
that distinguishable?
Perhaps. I mean, again, a lot of times when the Florida Supreme Court considers 3850s, they also consider 9.141s in the context of failure to raise issues on direct appeal. And that's also the way, in Hilton at least, that the ways these claims are being raised. But again, in a direct appeal claim, on a direct appeal, the issue is it preserved? If it's not,
No, she asked if it was
can
distinguishable.
it be reviewed for fundamental error? I submit that there are some things that cannot be. Generally speaking, the failure to renew a cause challenge is not something that's going to be reviewed for fundamental error. The court's been clear about that. And if there is a specific waiver on the record, we don't have that here, then no, you wouldn't be able to review it for fundamental
think
error.
you don't
Waiver
have it
trumps
here.
fundamental error. We don't have a waiver here, and I submit that fundamental error is still the standard.
But surely you're not arguing that now a trial judge has to, who's represented, a defendant's represented, now a trial judge has to look to the defendant who's represented by counsel to say, do you individually accept a jury?
I have no idea why the judge did that in this case. But
I know why the judge did this in this case. The judge had enough Adelson fuckery. That's why he did it in this case. The judge continued to look at Donna Adelson and ask her, are you on board with all of this? The judge was trying to make sure that everything was running smoothly. I'm pretty sure that's why the judge did it in Charlie's case. He did it all the time in Donna's case.
But are you promoting a bifurcated question by a trial judge to counsel and a defendant?
I think in the context that the judge is asking the question in this case is it fairly could be construed as, do you have any other strikes? And that's why, and every time that question was being asked, there was a strike, because there were back strikes in this case. So ultimately, when he just asked the same question he'd been asking up until that point, the question was, do you accept this jury, i.e., do you have any other strikes? And I guess let me throw out there, you have no other strikes, so you have no choice but to accept the jury. That's why it's being said here. Again, I acknowledge it's incumbent upon defense counsel to jump in and specifically say, we renew the objection, but if that's not done, it's still reviewed for fundamental error. I see that I'm getting my rebuttal time. I would like to make a couple other quick points about the merits.
Out of
I'm
time.
going to extend your time by...
When all of you are asking, how is he talking so fast? He's on a clock. And he needs to tell the judges what they need to hear. He's on a clock. And so he is talking literally as fast as he can because time is ticking down. He just said, I know I'm into my rebuttal time. But the bench wants to ask all these questions and wants answers to them. And you want to provide them an answer that might help them think about your filings a little differently. So he's just like, let's go, let's go, let's go, let's go, let's go, let's go, let's go.
By 5 minutes, I'll do the same thing for the state.
Thank you. I
And the judge is like, yeah, we've asked you a lot of questions.
appreciate that. I do need to address, so we have, and I've already talked about this, the almost 40 or a little more than 40%. We have the Tallahassee community. We have the different ways that social media infects jurors in a community now. But we have more than that in this case. In Patton, the U.S. Supreme Court said exactly this: adverse pretrial publicity can create such a presumption of prejudice in the community that the jurors' claims that they can be impartial should not be believed. The U.S. Supreme Court is saying that
And they're saying that, and they probably are saying that on a record where there was a record that the media exposure was indeed adverse.
Well,
And
but-
again, we can't presume that,
But
can we?
let me go further with that, Your Honor. What they're saying is there could be such intense media influence in a case that we may not even believe what the jurors are saying. And if I came to you with no evidence in the record and said, that's what we have here, you would say, Mr. Rufferman, you're speculating. We have 2 instances where jurors lied directly to the trial court. Ask
What?
point
Are we
blank.
supposed to just,
Bro, what? Dude. That's spicy. I mean, I imagine they just got yeeted, but that's spicy. Jurors are lying? Ooh. Who would lie to that judge? Can you imagine the fucking audacity? The audacity. Oh, some of you are like, why are we just hearing this? I didn't watch Charlie's trial. So I didn't watch Charlie's trial. So I'm curious.
assess the credibility of these jurors? Is that what an appellate court is to do under this?
No, that's not what an appellate court is to do. That's not the role of the appellate court at all.
Lied directly to the trial court. Ask
So are
point
we
blank.
supposed to just
Damn.
assess the credibility of these jurors? Is that what an appellate court is to do under this theory?
No, but what we have in this record is 2 instances where jurors were specifically asked, have you formed an opinion about guilt in this case, or have you posted anything on social media about this case? In both instances, the jurors said no. In one case, thanks to good defense counsel, good lawyering, they had a couple of posts from that juror and presented them to the trial court where that juror had said that the parents of Professor Markell should assist in killing Mr. Garcia.
Oh, shit.
And then went further when my client was charged and said, surprise, surprise, Mr. Adelson is charged. But the worst one is by far the next one. Mr. T is how I refer to him, as
Oh, shit.
the first initial of his last name. Mr. T stood in front of the trial court and when asked, have you formed an opinion about whether or not this defendant is guilty? He point blank told the court no. Lo and behold, 2 jurors later, Miss M comes in and by happenstance is asked the question, has anyone been discussing this case amongst the jurors? Oh, why, yes. In fact, that gentleman that was just excused with the glasses, what's he been saying? He's been going around telling other jurors that Mr. Adelson is guilty.
What?
And both of those jurors were
That's so dramatic. What? Oh my God. So juror T, have you expressed any opinion on this case? No. And is going around the jury room being like, this motherfucker is guilty. Oh, shit. Judge Everett must have been so fucking mad. Oh my God. Damn. That's some spicy shit. However, I can't imagine that after Judge Everett looked at them and went, excuse me, Juror T, I am unendingly disappointed in your chosen conduct. You are excused. I can only imagine Judge Everett was just like, I am disappointed. And then he would get on his keyboard. Oh no, damn it. Damn it.
Mr. T stood in front of the
Hold
trial
on.
court and when asked,
That was me. Ah. Shit. I was trying to dramatically keyboard. I fucked it all up. There we go. Dramatic keyboard. No juror snacks for you, Mr. T. Lying to Judge E. The fuck? All right. Sorry, counsel. That was so dramatic. He had the best time making this argument, though. Come on. Look at this attorney. Look at him. Look at how animated he is. He's like, they lied. They thought he was a murderer. Oh, my God. Counsel's having the best time.
One case, thanks to good defense counsel, good lawyering, they had a couple of posts from that juror and presented him to the trial court where that juror had said that the parents of Professor Markell should assist in killing Mr.
so
Garcia.
fucking dramatic. Don't
and then
do
went
that.
further when my client was charged and said, surprise, surprise, Mr. Adelson is charged. But the
I mean, everybody following this case kind of felt that way, though.
worst one is by far the next one. Mr. T is how
I
I
had to
refer
back
to
up
him
'cause I
as
was
the first initial of his last name.
riveted.
Mr. T stood in front of the trial court and when asked, have you formed an opinion about whether or not this defendant is guilty? He point blank told the court, no. Lo and behold, 2 jurors later, Miss M comes in and by happenstance
dramatic.
is asked the question, has anyone been discussing this case amongst the jurors? Oh, why, yes. In fact, that gentleman that was just excused with the glasses, what's he been saying? He's been going around telling other jurors that Mr. Adelson is guilty.
So crazy.
And both of those jurors were excused for cause, were they not?
Yes, but statistically,
well,
if those two,
they got
it's very
yeeted.
hard to prove someone's lying. Usually you rely upon some luck or some good lawyering with coming up with the post. So we know that one juror reported the other juror, and that's how we know that juror was lying.
And then being careful, defense counsel was offered the opportunity to review the tapes of the jury assembly room to see what comments were made, what are the reactions.
I've never seen that happen in a trial. Defense counsel was given the opportunity to watch the recordings of the jurors talking in the jury room? What?
Of the other jury members, and defense counsel said, no, I don't want to see it.
What?
But here's the problem with that.
Okay. What? You're telling me that Adelson's defense attorney, after juror T was walking around telling other jurors, this motherfucker guilty, he was told, you can watch the video of the jury room to ensure what happened. And he said, no thanks, we're cool? Why is this so crazy? This is the appellate court. Why? What the fuck happened at the beginning of the trial? I've never even heard of that. Oh my. Okay, so for those of you asking about the jury room being recorded, hold on, time out. There's confusion. This is the jury assembly room. This is not where they're deliberating. This is the jury assembly room before the jurors get picked. This is where everybody's just sitting in the veneer, waiting to get selected for jury service. There is not recording in the jury room where they deliberate. Jury assembly room is different. This is even before a jury gets seated. So before a jury gets seated, they're in the jury assembly room chatting if they're chatting. And that is what's recorded. Because before the jurors got seated, when they're coming in and doing one by one voir dire, Juror T came in and was asked those questions, and Juror T said, no, I've never expressed opinion about the case. And then another juror, 2 jurors later, came in and said, did anybody talk about this case? Yeah, that dude that was just in here told me he thought that dude sitting over there is guilty. Wow. And then they're like, okay, counsel, you can go watch what the jurors are saying in the jury panel room, the assembly room. And he said no. Who says no? I'm stunned. I'm stunned by all of this. This is wild. There's so much drama.
Defense counsel was offered the opportunity to review the tapes of the jury assembly room to see what comments were made, what are the reactions of the other jury members, and defense counsel said, no, I don't want to see it.
But here's the problem with that. And going to the second claim now.
No,
the second
that's the
claim
problem.
is a very specific.
The problem is that counsel said no, and you can't undo it. You're stuck with what the trial attorney did. How much has that got to suck? How many of you end up with this at work? Someone else does some shit, and you're dealing with it later? Yeah. Appellate law. Wow. Wow.
Easy fix. We know for the second group of 50 jurors, 51 through 102, problems were happening. We know about halfway through jury selection, it's reported, number one, that jurors have not followed the judge's direction, so much so that the judge, when he heard about this, after two of the jurors reporting that the jurors have been talking about the case, goes out and admonishes those jurors.
Can you imagine Judge Everett coming out and yelling at a 50-person panel of jurors and being like, I told you all not to talk about the case. What are you doing? Who are these people? How in the world? I would burst into tears. Even if I was one of the jurors that was sitting there being like, excuse me, the judge said we can't talk about the case, because that would be me. Excuse me, the judge said we can't talk about the case. If he came out and yelled at the group, even though I was not the one talking about the case, I would still want to fucking cry. I would want to cry. It's like when you have to run laps and you're like, I didn't fucking do it. Why am I getting punished? Oh my God. Oh my God. Oh my God.
Pretty sternly, do not talk about this case. But we also know...
But the problem is the content of those communications. And they were like this. High-profile case. It's the Charlie Adelson case. It's the Dan Markell case. Which of the... And that he's guilty. But again, the trial court offered your client the opportunity, the defense counsel, go listen to the recordings in the assembly room and you can bring back some statements that would in fact taint the jury. How did these statements taint the jury?
We have four statements, right? So we have one where a juror said, we've been talking about it all day, is literally the quote.
They gave defense counsel the opportunity to go watch it and build out an argument, and he said, nah. That's on counsel.
We have another where there's some pretty...
Talking about it, I mean, content. Let's get to the content.
Talking about the case all day.
Again, but that you could have questioned those jurors to get specific information on what content tainted the jury.
Okay, that's one juror. A second juror then said that there had been a lot of talk about...
He just ignored what the court said.
He's a professor at the law school and revealing a lot of the facts about the case. There was a divorce going on between the professor and the wife, but the two that are far the most concerning are the two jurors that specifically went back, a male and a female, the one with the glasses and then an older female that went back and told the other jurors he's guilty. In fact, if you look at juror C on page 2581, you have, coincidentally, when she's asked, after she reports that she's heard that this female juror is saying that he's guilty, oh, what's your opinion? I think he's guilty too. This is influencing that set of the panel.
He's talking about a 50 group segment. Remember, Judge E brought them in like groups of 50 and then questioned them one at a time, 130 of them. He's arguing that whole group of 50 that was like chitty chatting should have been yeeted. And it seems that Judge Everett said, go watch what they're saying in the jury room then and come back and tell me if this group of 50 is tainted. And the defense attorney was like, nah. Okay, well then, tough. Because then you only have what these jurors said, and these jurors were yeeted. I can't believe the defense attorney didn't go watch. That's wild. Have you no curiosity? Even just to give yourself more time in jury selection, aren't you nosy? Don't you want to know what they're saying? Y'all need to be more curious, counsel.
We have four statements.
Someone in court is watching this on their device? Did you hear that? There was like an immediate playback with delay of what's happening. Someone's got their phone open in court. Listen.
That she's heard that this female juror is saying that he's guilty. Oh, what's your opinion? I think he's guilty too. This is influencing that set of the panel. We have four statements. let me come back to why I think this was an easy fix. There was three groups of 50. It was clear 8 of the jurors that sat on the jury came from this middle group, 51 to 102.
8 of the jurors that were seated, 8 of the jurors that were seated came from the group that was, he says, chatting in the jury room. Yeah, I think somebody's listening. No, they're not listening to our stream. We're 2 days behind. Someone was listening or had their phone on this hearing being streamed in court. That's bad. Oh boy.
The midway point, the judge admonished the jurors to no longer talk about the case again. And the judge said, from this point forward, every juror, we should ask them, have you been discussing the case? Of those 8 jurors that came from the middle group, 4 preceded those 2 things. So for those 4 jurors, we have no, and I can quickly tell you the page numbers regarding those. I have the names, I apologize. I will say them. It's Brazos, 2467. It's Kraft, 2497. Milne, 2514. Hawley, 2528. Those 4 jurors were all exposed to
somebody saying, I think that the defendant is guilty.
Yes. Multiple times.
Okay, so they rendered that. So you have jurors who probably shouldn't be serving and didn't serve, is my understanding.
How many other were influenced
expressing
by that?
their opinion that the person was guilty? But don't we typically? We're going to strike a panel or require the striking of a panel when facts come in that would otherwise not be admissible. Isn't that the typical standard for striking a veneer?
Strike 50.
Yes. That is the tip. Yes, that is the typical standard for striking a veneer. Also, Your Honor, thank you. Thank you. Because even if I am wrong, it is a hill I will at least stand and fight on, that it is veneer, not venery. I cannot wrap my brain around the pronunciation of veneer being venery. It might be the proper way to say it. Can't wrap my head around it. Can't do it. Nope. At all. So thank you, counsel, for also saying veneer. Appreciate it. Or Your Honor. Let's keep going.
Jurors. Just those 50. The clerk actually said.
But the reason for it isn't that somebody has rendered an opinion as to the guilt of the defendant. It's whether they've been exposed to facts about the case that would otherwise have been inadmissible.
Oh, I don't agree with that, Your Honor.
Those are not facts.
Jurors.
Counsel, those are opinions. Those are not facts. Those are not facts. Merely opinions. That's an opinion of guilt. That is not a fact that's not coming in evidence.
Constantly saying, when they've been told not to talk about the case, talking about the case and saying he's guilty and being exposed to that, when you already have all of the social media presence that's involved in this case, that's improper. And again, the fix was easy. When they weren't sure in the third group of 50 whether or not they were going to finish, the clerk said, we have another group of 50 downstairs. How easy would it have been for the judge to say, wow?
How easy would it have been for counsel to have said, yes, I want to watch what they said?
I mean, he was mad, you could tell. I'm frustrated. They're not following my directions. They're lying.
Couldn't we have sidestepped some of the speculation if the tape
had an
of the jury
affidavit.
assembly room had been reviewed and then some content specifics argued?
I think it's clear that this 50 was tainted. And if you go back to the Manning.
The appellate court coming in with the practical. Hey, wouldn't we just know if counsel would have just, I don't know, watched the tape? Maybe.
Case, what the Florida Supreme Court said that every reasonable step should be taken to preserve a defendant's trial by an impartial jury. And to this end, if there is a reasonable basis shown, the court should take action. There's, without question, a reasonable basis. We have one juror that said, you living in Tallahassee, you'd have to be under a rock to know about this case. Another
That's not answering the
juror
question.
said, the impact that this had on me, when you hear about this, it sticks with you. We have so much about this case, but then when you boil it down to
That's
that
not what
middle
they
50,
asked.
and we know that there's not one, not two,
Oh my God.
4 different jurors that has disclosed that they've been talking about the case,
No.
and is getting the judge frustrated. He has to re-admonish them, but he doesn't go back and question the ones that have already been questioned about whether or not they've heard discussions from other jurors.
They didn't go back and question the jurors that were questioned before they found out that these conversations were happening. Therefore, when defense counsel had the opportunity to watch the tape, he could have watched what was said in the jury room and said, these jurors who we already questioned were in that group. And then could have filed an affidavit saying these jurors were all part of that group. It's too late now. Literally, it's too late to apologize, counsel. It's too late.
And 4 of those jurors who were never
late.
questioned ultimately sat on this jury. That's a reasonable basis for the judge to have taken the easy step. You're right. At this point, I'm frustrated. They're not following my instructions. 51 through 102, they're done. Let's bring up the next 50. I will be very clear going forward. He was. And if we need to go to the 4th 50, we will. That's what should have been done. And because of that, my client didn't get a fair trial. I'll reserve my last minute for rebuttal. Thank you.
And I will extend you an additional 3 minutes, and the same for the state, so you'll have a total of 8 extra
I mean, counsel, your word per minute was quite high in that argument. There was no lollygagging.
minutes.
Thank you, Your Honor.
May it please the court. My name is Charlie Lee. I work for the...
Hello, Charlie Lee. This is the argument for the state of Florida. Because remember, this is the case is Florida versus Adelson. On appeal, it's Adelson versus Florida. So this is the state's argument.
The Attorney General's office, and I represent the state of Florida in this case. I'd like to start out with the questions that judges here have asked today. One thing I do want to clear up is the preservation issue that Mr. Adelson claims in Manning in his reply brief. He talks about that in that case, the attorney below never filed a written motion, didn't renew his objection to the jury or anything like that. Those facts come from the dissent in Manning. The 3 justices of the Florida Supreme Court who felt that Manning should not have his conviction overturned, who felt he did get a fair trial, noted that his attorney affirmatively accepted the jury. Now, from Manning, we come to Armstrong.
It's tough when you got to go to the dissent.
And Armstrong is backed up by all the cases where we have Batson challenges. If someone files a Batson challenge saying they didn't have a fair jury because of the demographic makeup of their jury, if they affirmatively accept that jury, then they've affirmatively waived that objection. They have to do it once again. They cannot accept the jury like Mr. Adelson did twice. To his jury and to the alternate jurors.
I mean,
But isn't really, change of venue is not the same as failure to renew specific challenges to specific jurors. It is a much broader, as Mr. Ufferman was talking about. It has to do with what was known by the community. It's whether the community is one that cannot hear the case. It's not necessarily about individual jurors. So why should we apply this rule that I understand what Armstrong says, but I've also read Joyner, and I know that that's where the Supreme Court first made this rule very, very clear, and they made it in the context of challenges to particular jurors. Why should we apply it? Forget what Armstrong says. Why should we apply it?
You should apply it because it is about individual jurors. Because Mr. Adelson, he's entitled to an impartial jury. He's not entitled to an impartial community or city or world. There are people out there who are going to prejudge Mr. Adelson's case. There's people out there that will prejudge every case. In every jury selection, there will be jurors on the panel that will say that they believe the defendant's guilty just because he's sitting in the defendant's seat. That happened in Mr. Adelson's case.
Shouldn't
It'll happen in
It
every
does
case
happen.
that's tried this week. at the Leon County.
There are absolutely people that walk into the courtroom, look at the defendant, and are like, what'd you do? Why are you here? What did you do? What did you do? Yeah, that will happen.
Courthouse. It has to do with the actual jurors. One of the things that Mr. Adelson brings up in his reply brief is structural error, and I'm going to explain why this isn't structural error, although Mr. Adelson has waived that because he didn't bring it up in his initial brief. But
you're not coming in here and arguing something that you only put in your reply brief. Oh, I hate that. You don't. No. You have to put it in your brief.
let's look at the 12 actual jurors that served on Mr. Adelson's jury. Adelson accepted all 12 jurors during the pre-screening phase. All 12 said that they would be fair and impartial. Mr. Adelson gives us no reason to believe them. As Judge Thomas pointed out, there's not a clear record here of why we shouldn't believe them. And Judge Rowe pointed out, because affidavits weren't filed in this case, we don't know what the pretrial publicity is. This isn't like Shepard v. Maxwell. This isn't like Irvin v. Dodd, where you...
Bingo. Shepard v. Maxwell. Bingo. It's a deep law school cut right there.
You know, Mad Dog Irvin was in the press, as serial killer in the press all the time. It's not like those cases. We don't know because Mr. Adelson didn't file a legally sufficient motion.
But he did show that of the 54 prospective jurors who had a considerable amount of media exposure, that 53 of them found that Mr. Adelson was guilty and said that they couldn't be impartial. Now, there's much of jurors might be lying about whether they had the exposure. Is it also possible that jurors were lying that they couldn't be impartial and absolutely thought he was guilty to get out of jury service? I mean, I think there's a lot of speculation going on here that we really can't get to.
Well, that's where
Court seems a little more friendly to that side. Seems a little more friendly to that side. Isn't it possible that jurors are just lying and is like, yeah, I heard about this case. I think he's absolutely guilty. Let me out of jury duty. Those are the words, right? I think he's absolutely guilty. Cannot be fair. Are those the right words to get me out of jury duty? Fair, Your Honor. Fair.
Point to Singer, a case that Mr. Adelson relies upon. And in that case, and this is a 1959 Florida Supreme Court case, they said that the Florida Supreme Court said they had some doubt as to the impartiality of a fairly large number of the veneer men, which might be indicative of the inhabitants generally of the community. But we cannot determine error on doubt. That's the Florida Supreme Court in Singer.
So would it have been different, for instance, if Mr. Adelson had brought forward evidence that there were 100 broadcasts on the Preston Scott Show, that there were 200... Oh boy. The failure to properly file is going to be in their written opinion whenever their written opinion happens. And they're going to say, this is why there needs to be an affidavit. And there was no affidavit, so there's no way we can know. The issue is not properly preserved. It said written motion plus affidavit. No affidavit, no review on appeal. Interesting. 100 pieces by WCTV, 300 articles in the Democrat, 50 podcasts and court TV programs, and that all of the speakers in those programs, or some high percentage of them, pointed to guilt for Mr. Adelson. Would that be different?
It might be different. All we have is secondhand knowledge.
Because we don't have that info because they didn't do it.
That were there.
Right.
That's all we have. It might be different. We have, I think, the court TV host is the only one that we know expressed a negative opinion.
And even the jurors who were...
Which one?
interviewed about their exposure to the media sources I just listed. Some of them found that those sources were credible, and some of them found that they weren't credible. They called into doubt whether the person who was on one of the news programs was partial or not, right?
Correct, Your Honor.
I mean, that's fair.
As to Mr. Adelson's numbers, I disagree. I noted he quotes 29 jurors in his initial brief. I noted 22 that said they couldn't be fair and impartial. But even saying it's 40%, which I believe is what he's arguing today, that's a far cry from Irvin, where it was 2/3 of the jurors had extreme bias against Mr. Irvin. I mean, he was a serial killer that in the press, I believe, several states had, sheriffs had said that they were going to make sure that he died, was executed.
I mean, that's strong.
One of the cases, Murphy.
That's just not the case here.
And I do agree with Mr. Adelson. There are some similarities between issue 1 and 2. And moving on to issue 2, we have to give jurors credit. Just because this young man said that Mr. Adelson was guilty, and another man may have forgotten what he posted on Facebook about Mr. Garcia, that doesn't mean that the entire jury pool was tainted.
I mean, saying that the victim's parents should go kill someone is a pretty strong take. However, how long ago was it? Because this case did take almost 10 years to go to trial from the time the killing happened. However, pretty strong take.
As Judge Thomas pointed out, the defense counsel was given an opportunity to go back and review video of the courtroom or the jury assembly room wherever this happened. They were moved from the jury assembly room to courtroom 3G, and the defense declined. So we don't know. There's no indication that this young man.
The fact that the defense declined is going to come up in the court's ruling, I feel. It's wild.
Stood up on a chair and yelled this out at the jury pool in general, or whispered it to someone, we don't know. As far as the gentleman with the Facebook page, we don't know exactly what he posted about Mr. Adelson, other than he said something about surprise, surprise. And the defense counsel didn't establish a record. And again, going back to Singer, we're not going to reverse this case based on doubt. This isn't a case, because this is not a structural error, and neither the U.S. Supreme Court nor the
Bowtie's amused. He's just sitting there smiling. At counsel. Okay.
Florida Supreme Court has ever held that a failure to change a venue, or denial of a change of venue motion, or prejudice within the community, or bias amongst prospective jurors has ever resulted in structural error or per se reversible error.
Didn't the Manning court, though, suggest that a venue error is a structural error?
I don't think so, Your Honor, because they looked into, the majority in that case looked into the individual facts, case by case. When we get to Rawling, there, and McCaskill, there the courts, and that came long after Manning, they've developed a test to find out. And this is why, in this case, we had 2 voir dires. We had the pre-screening process and then the actual voir dire, which is, far more than the average defendant gets.
Yes. It was, yes.
And that's so we can suss out and we can identify prejudice amongst those jurors, because no court has ever held that, bias amongst jurors in the jury pool would result in a structural error, because that doesn't affect the framework. Now, if there was something inherently wrong with the voir dire process, perhaps. Now, no court's held that either. But in this case, there was no problem in the voir dire court. The judge here went above and beyond by having the pre-screening process, then the voir dire, where counsel will get an extra chance to challenge jurors. One of the things in this case is the defense counsel didn't ask for any extra peremptories. He didn't even use all 10 of his peremptories until the very end of the voir dire.
Barely used all 10 of their peremptories? Huh. Then they must not have been that mad. They must not have been that mad about the jury.
process, which is a factor in Manning. And it's why we have those factors, is because with structural errors, those are errors that are so, such as a right to an impartial judge. It's not like we can question a judge or the right to a defendant's right to represent themselves. We can't question a defendant about why he wants to do that. Or a public trial. If there's no public trial, we don't know what happened. We can't peer in. We can't look behind the veil and see what that error might have caused. But in this case, it's perfectly clear. Mr. Adelson agreed to 58 jurors. The jurors that served on his jury, only one of them heard another juror talking. 3 of them had no prior exposure to the case. And and all of these jurors, Mr. Adelson agreed to.
Well, could you address, the preservation issue aside? Let's go to, can you address Mr. Ufferman's fundamental?
The preservation issue is a big issue. She's like 10 out of 10. Notice that the state is talking less. Right. They don't have as much work to do to convince the appellate court that they're right. The defense has a long way to go to try to convince this panel that they are correct. Easier for the state when they're like, but Your Honor, no. Obviously. It's easier.
Error argument.
So she's like,
I don't think
putting aside the preservation error because glaring and we all can see it. Can you just answer these questions?
The preservation issue aside, let's go to, can you address Mr. Ufferman's fundamental error argument?
I don't think that he can show fundamental error because he can't show that in any other venue that Mr. Adelson would receive a fair trial. This case,
there's
in
no
modern
affidavit.
cases often, a fair trial, a different trial, a different result.
Right.
Fundamental error requires the defendant to show that a different result, but for the lack of change of venue, that his case would have ended up differently. Well, that's not the case
There's
here.
no way
been no
he's
demonstration
gonna
of that.
be able to show that.
So it's not just fundamental error that he didn't get a fair jury. Wouldn't that be fundamental error in and of itself, regardless of what the outcome of the trial was?
Well, if he could show that he didn't get a fair jury, but he certainly did.
Well, that's his claim.
Well, it's his claim, but he hasn't shown any evidence of it. He hasn't.
The state's argument is like, Your Honor, obviously. No. Well, that's what he's arguing. Excuse me, Your Honor, but he's wrong. But he continues to just be wrong.
Shown why this particular jury, these 12 jurors, were so biased that that the outside influence on these jurors would have changed their verdict. He's made no showing of that whatsoever. He didn't try to poll them. I mean, they polled them after the trial, but he didn't try to question the jurors or anything like that. There was a motion later, but there's no evidence in the record that these jurors were influenced. Like I said, 3 of them had never even heard about the case. So there's no evidence in the record whatsoever that his actual jury, because he has a right just to a impartial jury, that they were influenced by the media and the
an affidavit would have helped
the
with
local, the conversations around Tallahassee influence their verdict. There's nothing in the record.
I think his argument is that the media saturation implicitly biased the jurors, I think, is one argument. Maybe another argument is that they are lying. They were lying when they said that they could be impartial. And he's pointing to the 2 jurors who did, in fact, lie. And then again, he points to the 53 of the 54 jurors who were excused for cause because they had consumed the media and felt that they could not be impartial in this case. So that's the evidence he's pointing to. What do we do with that?
Well, Mr. Adelson is asking this court to presume prejudice there, which is something that this court could only do under a structural error argument, which he's waived, and no court has ever held that it's a structural error.
They're asking about fundamental error. He's talking about structural error. I don't know if we'll have time to get into the vis-a-vis of the 2 today, but they are talking about the 2 standards for review of the type of error it may be. So getting into the more really nuanced legal arguments about what kind of error this may be.
This court should not presume error. And Mr. Adelson has not proven any error. He hasn't proven by not filing a legally sufficient motion.
The affidavit.
With affidavits that show what the media coverage was. We had that in Foster. In Foster, the defendant there
But Your Honors, it's not about the pasta.
News clips, articles that were far more negative against Mr. Foster than anything that we heard. All we have is secondhand accounts from other jurors or prospective jurors about what the media, publicity was. But assuming what they said was true, what happened in Foster was far worse, and what happened in Rawling was far more extensive. And this court, there's no reason this court should presume prejudice. And if, there's no reason this court should find prejudice if Mr. Adelson hasn't proven it, and he has not.
Well, Mr. Adelson argued in the brief, or counsel argued in the brief, again, that the media environment in the Rawling case in 1994 is substantially different than it was when Mr. Adelson's case went to trial. What do we do with that?
I mean, the media
I don't
is
think that's
fundamentally
necessarily
different.
true.
The media is fundamentally different.
We don't know much about Mr. the media coverage around Mr. Adelson, but in this day and age,
affidavit.
No media is really local. And in this case, there was over the My Dead Body podcast, there was national news. People were following this all over the country and all over the world. The environment hasn't really changed. Really, the important thing is local sentiment. If it's something that shocked the community, this is as bad as Dan Markel's murder was. 30 people on the jury, prospective jurors, had never heard of the case.
Right.
In a town like Tallahassee, where people are coming and going,
that's a good point too.
Quite a bit. It's even less than in Gainesville, sort of the same situation with Rawling, but in Foster. That murder there with the extremely negative publicity didn't warrant a change of venue. And Foster was after Rawling. So I don't know that, I understand Mr. Adelson's arguments at times have changed, but I don't think people have. It's when we do go to pick a jury, we ask jurors, in that community, can they be fair? What have they heard? Can they set these things aside? Because after all, that is the standard in McCaskill, not whether they've been exposed, but whether they can set aside that exposure.
As long as we're talking about distinguishing the Rawling case, does it matter that
I'm not leaving.
we have
I
a
just have to move
notorious
my
murder
heater. I am
and we have
so
a lot
cold.
of media from it? In the Rawling case, we had a literal serial killer on the loose, killing people. I don't think anybody in Tallahassee believed that somebody was going to pay Garcia and Rivera to come up to Tallahassee and kill them. That was not
The fear of the community is different.
Belief in Gainesville when there was somebody who...
The fear of the community is different. It was a huge factor in the Kohberger case. A huge factor in the Kohberger case was how on edge the community of Moscow was in the time between the quadruple homicide and somebody being arrested. That's different than seeing a news story and being like, oh, that's wild. Just a whole different thing, especially in a smaller community. So I understand why the court's distinguishing the two.
Literally was brutally killing people day after day.
Yeah, that's a different kind of terror.
That has nothing to do with the media coverage. That has nothing to do with what was happening in 1994 when he was being tried. But does it have anything to do with the decision of whether to change venue when you have something well beyond the media in assessing how the community may have felt?
I agree.
Court's like, tell me why I'm right on this point and make this point, please. I'm on your side. Make this point.
Your Honor, in Rawling, the Associated Press described him as the next Ted Bundy, basically. And there is that fear and that shock. And
Who? Who was name calling him? I'm sorry. Who was name calling the defendant?
I agree, Your Honor.
Who?
In Rawling, the Associated Press described him as the next Ted Bundy, basically. And
Helpful.
there is that fear and that shock. And I don't want to downplay Professor Markel's death. It was shocking. It was terribly sad. But you're right. It was certainly figured out that this was a murder for hire. And by the time that Mr. Adelson went to trial, this court had already affirmed Garcia's conviction. This was a murder for hire plot. The people in the community were not at danger as they would have been with Rawling or Bundy or even Foster with these Lords of Chaos group. I agree with Your Honor that when that fear stays in a community, that can certainly poison their minds. But in this case, that fear that would have been there in Rawling and Gainesville in the 90s would not apply to Mr. Adelson's case. And
the fear of the community was such a huge factor in Idaho. And it's a very unique factor. And counsel's pointing out the difference between, look, the community terror of a serial killer being on the loose is very different than a targeted murder for hire. It's just not the same. It's fair.
And like I said, it's not surprising that only 22 jurors said that they could not set this out of their mind. I know
Isn't there a difference here, though? I mean, unlike the Rawling case, there's been, now 12 years of sustained media coverage. There have now been 5 convictions in this case, and at the time of the trial, there had been 3 prior to Mr. Adelson. Doesn't that make a difference?
I think it can work both ways. I think the saturation and the fact that this case has been going on for so long may dull the senses of people. They hear about it, they get disinterested the more they hear. I mean, but
Adelson's counsel's just sitting there, just grinning, just sitting back there being like, "What, counsel? What's so funny?"
I think
having the best time back there listening to these arguments.
In Rawling is the time of the publicity.
Look at him. He's like, oh, you with your arguments.
and the trial itself. In Mr. Adelson's case, the crime was far removed. 9 years, as one of the jurors pointed out, prospective jurors pointed out. But the nature of the coverage matters a lot too, and the nature in relation to the time of the trial. And there's nothing in the record to indicate there was negative publicity about Mr. Adelson around the time of his trial that would influence the jurors to reach a guilty verdict instead of an innocent, or instead of acquitting him.
And again, that's perhaps where an affidavit may have come in and to help the defense in terms of how many media.
How badly does the judge want that affidavit to exist?
Stories there were within the relevant period, the content of those stories. Again, we don't have that in the record. We just have sporadic references in the record where jurors were reporting that they had seen some media at some time.
I'd argue it's why the rule exists. It's why the rule requires
as long as we're talking about the rule, counsel, I noticed, Armstrong talks about how a change of venue motion is premature until there's been an actual attempt to impanel a jury. I understand what they're getting at, just on its face, but I'm having trouble understanding how that requirement it plays into the requirement that there be a written motion for change of venue. Do you try to, do you attempt to impanel a jury, and then when you can't, you say, hold on, Your Honor, give me a few minutes so I can write out a motion for change of venue because the rule requires.
No, Your Honor. You have it pre-written because you know you're going to make the argument, and then you drop it like it's hot. You know you're going to make the argument. You have it pre-drafted, and then you add in details in the facts section. The law should already be drafted. The law's not going to change. The legal arguments aren't going to change. You just bolster it with your facts, and you ask the court, Your Honor, we are going to need to suspend voir dire so we can make a motion for change of venue.
Be in writing. In other words, is the requirement to be in writing unrealistic, given the separate requirement that a motion is premature until you attempt to impanel a jury?
No, Your Honor. The rule is not unrealistic because it requires the defendant to make the initial record that he needs to make, and that is, if you file it before, if the defendant files the motion before trial and has the affidavits, which he should, like some of these cases, they went around town doing polls.
We've watched that happen in multiple cases
Foster,
now.
they got the news coverage and everything before the trial. So it incentivizes a defendant to go out, get the information, poll the community, make the record for their motion, file the motion ahead of time. The court's under advisement that this is an issue, which in this case it was an issue even before jury selection.
And that's what Donna did. They filed the motion. The court says, I'm taking it under consideration, and I think we need to readdress this when we get to voir dire. And then they made a renewed motion and incorporated their prior motion. That's exactly what the Adelson attorneys did for Donna, not for Charlie.
The court then, the judge in this case, then wisely took the effort to have a pre-screening process and a voir dire. And so the rule is not unrealistic. Now, the Florida Supreme Court says that we have to go ahead and try to pick a jury anyway to see if we can determine whether there is, a bias within the community that can't be overcome. But we have to test that. That's one of the reasons I'm arguing it cannot be a structural error, because this is something we can palpably test. And so that's why I believe it's not. The rule makes a lot of sense that it requires a pretrial motion with the affidavits.
Anything else, counsel, or can we move it?
To conclude, I'll move on to issue 3.
I got to put you at 1.25, my guy, or we're not going to get finished today. Defense counsel or Adelson counsel, I can't listen to at 1.25, but you're getting a little zoomed at 1.25 because EDB is going to run up against a hard stop, and I did talk a lot this morning. All right, counsel. Final point.
Briefly, I think in this case, one of the things I want to argue about the evidentiary issues is
at 1.25, he now speaks as quickly as defense attorney at normal speed.
Mr. Adelson's, when he brought his text messages to the court, he never took the opportunity to untangle them for the trial judge. And the trial judge should not have been required to do that for Mr. Adelson. And that's why I'm arguing it's not just unpreserved, it's an invited error, because when the
text messages?
The trial judge asked Mr. Adelson, if you can get some texts for me that are relevant, that would show what you're trying to prove. He just said all of them.
But that is their argument. Their argument is all of them should have been admitted, not one or two that the judge might find relevant, but all of them. How can you waive that argument simply by refusing to cherry pick ones?
Because the only relevant arguments would have been if there were any relevant. I argue that even these weren't relevant. But the conversations between Meg Benoit and Donna.
Oh, this goes to an evidentiary ruling at trial where Adelson's counsel focused. There's multiple points to this appeal, and that's why they're having oral argument. The third point of the appeal is that there was a error in not admitting all of the text messages that Charlie wanted to admit during trial. We heard about this a bit in Donna's trial as well, because it's my understanding that at Charlie's trial, as it came up in Donna's trial, he was arguing that he was being extorted by Catherine McBanois, and then Donna Adelson was trying to argue, see, he was being extorted. We didn't actually set this all up. You can't just admit all of them, though.
Adelson and Wendy Adelson. He didn't separate those out and offer those to the court and say, these are the relevant text messages and this is why they're relevant. He should have done that. The judge was under no obligation to untangle those for Mr. Adelson.
And I think there was concern about the content of the message. I think you characterized the messages in your brief as racist, misogynist, and sexist. And I can imagine that had those been admitted, Mr. Efferman might be right up here arguing unfair prejudice against.
Oh boy. Well, the court's like, counsel, some of those messages were racist, sexist, and misogynistic. So no, the court is preventing you from hitting yourself in the face. And the court's like, and if we had admitted those text messages, then Adelson would be up here arguing that it was error to admit those messages because it made the jury dislike him more. It prejudiced the jury against him, and those shouldn't have been admitted because they were unduly prejudicial. Oh boy.
I think you characterized the messages in your brief as racist, misogynist, and sexist. And I can imagine that had those been admitted, Mr. Efferman might be right up here arguing unfair prejudice against his client because of this bad character evidence.
Correct, Your Honor. The judge has to act as the gatekeeper of evidence in every case. And in this case, we may have very well had an ineffective assistance of counsel in the face of the record argument had the judge not asked pointed these things out to Mr. Adelson and asked him.
And now you've got the state saying it might have been IAC for the attorney to ask to admit those against his client. And the court was protecting against it. Oh boy.
Is it really the judge's job to protect the defendant from himself, though? I mean, if counsel believed that the strategy included admitting these text messages that might otherwise be viewed as negative to them, isn't that really a strategic call on counsel's part?
If it's a strategic call that no reasonable attorney would take, I think a judge does have to step in. A judge will have to step in even under a 403 analysis, if something's more prejudicial than probative. In this case, those texts were certainly more prejudicial than probative. Yes, a judge should step in.
Even if it's prejudicial to the offering party?
Yes,
now,
sir.
I'm not going to allow you. I think that would harm yourself if you admitted that, so I'm not going to allow that evidence in.
Stop hitting yourself as a valid argument, I guess.
I don't think I've ever seen that.
I think in the interest of not vitiating the entire trial, a trial judge should do that, and because otherwise, he's letting the defendant walk himself into a mistrial, and a judge should not allow that to happen or be forced to allow that to happen.
Yeah, you can't let a party invite a mistrial like that. Wow.
Based on those arguments, Your Honors, I would ask this court to affirm Mr. Adelson's conviction for his part in the murder of Daniel Markell.
Oh boy.
Court.
Nope, we got to go back to normal speed. Even though we need to zoom.
I'll begin by briefly addressing Claim 3.
He zooms on his own.
Here's why it was so prejudicial to my client to not get in the other text messages that the state was pointing to and suggesting that they had to have been about nefarious things as opposed to routine things. And the text messages that have been proffered, they clearly are routine things. This is what the prosecutor argued in closing, page 2082. Quote, but as the defense points out, these folks had independent relationships with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about murder or if these call flurries around key events are just coincidence? A conspiracy can be shaped like blah, 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 and she goes on. Without knowing the content.
Don't come blah, 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 Georgia Kappelman up in this chat. Also, the content of phone calls isn't going to be proven by the content of text messages. But the defense is arguing that the court erred in not admitting all these text messages, and the state attorney arguing the appeal is like, no.
The state objected to the jury being able to see all of the content. And now they seize upon that in closing argument?
Counsel, I just have to say, I applaud the drama that you are bringing to appellate court. I really do. A lot of appellate lawyers are pretty dry. Sir, I appreciate the theatrics of it. You clearly enjoy what you're doing. I don't think your argument is going to help, but at least you're like, we're going to give it our all. I appreciate it. He's like, how dare they? Ugh. Can you imagine? I love it. He's clearly having the best time ever, standing up and making his oral arguments.
And say,
I'll ask you the same question I asked the state. I mean, if these messages, which were labeled as racist, misogynist, and sexist, had been entered against Mr. Adelson, wouldn't you be arguing here that the jury was prejudiced against him in terms of this bad character evidence?
Absolutely not. Number one, that would be the actual definition of invited error. Number two, my client would be, I'm sure it's not great, but he can take the label of being racist, misogynist, whatever else. He doesn't want to take the label of being murderer. And these texts.
I mean, they did hear him on the jail calls. They probably have some names for him. He's like, he doesn't care. He doesn't want to be convicted of murder.
would have helped him show that what the state was arguing is not true, so much so that the state seized upon it. He doesn't need protection from himself, as Judge Winokur's already indicated. He has a right to put on evidence that he thinks is right.
He's like, Charlie Adelson is who he is, Your Honors. Charlie Adelson is who he is. But we're trying to say he's not a murderer, and that's where we're at.
Relevant. Mateo says any evidence that could be in any way, even in a slight way, relevant to the theory of defense, a judge errs in not allowing it in. The purpose of putting these texts in is not, as the trial court was saying, oh, do they go to motive or they go to any element of the crime? No, they go to showing that these are routine communications, not what the state is asserting. And he was prevented from putting that in, and the state seized upon it in closing.
Was this...
How rude of the state.
Is it not harmless? He was allowed to testify about these texts on the stand.
Wow, my client was out on an island in this case. There's no question that it was, one other witness was presented. My client.
Was it an island in the sun? Just a question. What island? What island?
Client's testimony. Is there anything to back up my client's credibility? This would have been something that the jury could have looked at and said, wow, Mr. Adelson saying that he didn't do this, he didn't hire these people, he's the one actually being extorted. But there's nothing that supports that other than his testimony. This would have been.
You gotta admit, all of you are saying, no, it's an island in the stream. Fair. You've gotta admit that counsel has a flair for his argument. I'm not mad that he's got a flair for his arguments. Don't necessarily agree with the argument, but I'm enjoying watching him make them.
Could have looked at and said, wow, Mr. Adelson saying that he didn't do this, he didn't hire these people, he's the one actually being extorted. But there's nothing that supports that other than his testimony. This would have been, wow, look at the text messages. See them for yourselves, ladies and gentlemen.
How was your client on an island? I mean, certainly he could have brought forward the mechanic he was having the conversations with and all of the other people to testify about the kind of communications they had with your client.
You all know very well that I think defense counsel was ineffective and had a conflict of interest. I'll raise.
I think the conflict of interest point is incredibly interesting. I think the conflict of interest point is incredibly interesting.
That at another date, should I need to?
But it's clear that your client was not on an island, that there could have been evidence presented that would have corroborated what was in the text messages.
I agree, and the judge prevented it.
Right.
That's the whole reason for Claim 3.
Counsel, I want to go back to something that we talked about at your initial argument about what needs to be shown to strike the entire panel. Now, I did look and I saw that this wasn't cited in any of the briefs, but I'm going to say it anyway. It's Morris, Florida Supreme Court from 2017, and the quote is, for the statement of one veneer member to taint the panel, the veneer member must mention facts that would not otherwise be presented.
They appealed regarding the conflict. We might have to go back and pull all that up. They did appeal regarding the conflict. They did not, to my memory, have oral argument on it. We might have to go back and talk about Charlie Adelson's appeal more. We talked about the conflict appeal a little bit, but we might have to go back. It's just going to take us till after the Richins case.
So is that the correct standard to be used in striking an entire panel?
That's one aspect of it, and I acknowledge that's not met in this case. Clearly, the facts that were discussed did come out during the trial. I think the bigger issue is the expression of guilt. So I think the case that's closest on point is Brower, cited by the state. And Brower, the comment that was being made by a particular juror was they should just hang him. And this is what the 4th DCA went on to say. This is on page 1027 of the opinion. The offending members of the veneer were facing a 3-week murder trial and were enduring a tedious and lengthy jury selection process. They certainly used poor taste and worse judgment. However, there is nothing in the record to indicate that the offensive remarks were offered or taken seriously. The 4th DCA is finding that the comment, he should just hang himself, was literally a joke, not an expression of the defendant's guilt. That's not at all what we have in this case. I see them into over my rebuttal time. I would ask this court to reverse, and I would end with this. If there was ever a case for a change of venue, these facts are that case.
Counsel, my colleague has a question, so
course.
I'm going to extend your time for her to ask it and you to answer it.
Thank you.
Inappropriate.
I'm extending your time because my colleague has a question. We will talk about the appeal because it seems that you guys are very interested. We will talk about the appeal on the conflict because that has been filed. We will not talk about we're not to IAC yet. We know this attorney's thoughts on it. We're not there yet, but we can back up and look at the appeal regarding the conflict of interest between Donna, Charlie, and these lawyers. We do not have time today, but we can go back and look. A lot of you are like, yes, we are interested. Fair enough.
Your last sentence said on the facts of this case, and that's what bothers me, and I would like a response from you. The fundamental error argument. In this case, on this record, we're arguing speculation. If you apply, if you're arguing fundamental error, and you're asserting speculation of prejudice by the jury, in practical application, you're lowering a fundamental error standard below even abuse of discretion to me. So, on this record,
right,
your argument on fundamental error to me, I guess, help me understand what more than speculation is backing up your fundamental error argument.
Help you.
Yes, Your Honor. And it would be, and I know they've been mentioned, but I will go and I have them written down right here. 40% of the jurors had formed, of the 130, belief that my client was guilty. Only one had not, or thought that my client was innocent. 3 prior cases, as has been discussed, and one of those cases was 2 trials, one of which occurred a year before. 10 years, almost a decade, this case has been going on in this, as the judge said, small community. 2 jurors lied. So it's not just speculation.
Which is fucking wild.
I was suggesting that, based on this, we can suspect that some jurors are not willing to tell the truth and really tell the court that they've already formed an opinion. We know 2 jurors lied. One of those, well, both of them lied and specifically had an opinion about the case. And ultimately, the jurors directly violated the court's order and talked about the case, even though the court specifically said don't do it. When you consider all of those factors in their totality, we establish fundamental error in this case. Thank you.
Thank you, counsel. Thank you both.
I appreciate counsel's dynamic style of argument. I appreciate the enthusiasm. He's working with what he's got. The hardest part of being an appellate attorney for me would be the absolute lack of control. You have to look at what somebody did in the trial court and work with the decisions that they made that you had no input on. It's why in these massive high profile cases, when you have defendants with a shit ton of money, like Diddy brought at least 1, but I think 2 appellate lawyers onto the trial team, because trial lawyers are not first and foremost focused on the appeal. They are first and foremost focused on the trial and preserving issues, but having additional appellate counsel to be like, hey, don't forget to do this, is rare, but a huge benefit. But it's why you see the massively wealthy defense attorneys or the massively wealthy clients bringing in appellate counsel to work with the trial team. Rare, but it's something you do when there's a lot of money at stake. We don't see that often in criminal. And as Lyndon in the chat pointed out, this is something you will see more in civil, 100%. 100%. There is so much more money on the line in a lot of these civil cases that you will have appellate counsel working alongside the trial team to help. Because the trial team's brain is like, I need to object here. But then you would have appellate counsel saying, no, but the rule buried in the book says you need to do these other things too, or you're fucked later. And once you don't do it, the shit's out of the horse. And that might be the problem here, that the court's like, look, you did not make the proper motions. You did not preserve this issue adequately for appeal. Too bad, so sad. And then we might see that roll into the IAC argument that counsel did not fundamentally do their job preserving this for appeal. I appreciate his enthusiasm.
Both. This court is adjourned.
All rise.
All right. It's going to take months before we see any ruling from the panel, the appellate panel of judges here. We will keep an eye on the Adelson appeals. I'm keeping an eye on Sarah Boone's appeals. We will look at appeals and cases that are connected to our cases as we get there. Remember, the judges are reading the entire record of the appeal. Thousands of pages, sometimes tens of thousands of pages. Cases go to oral argument much more slowly, and the courts are reading the entire case, the briefing, the research, and they have research attorneys researching the law with them. These are slow, nuanced processes where the courts have time to consider what's happening. This is not an immediate appeal, and it takes quite a lot of time. And then the judges will do their research after oral arguments. Then they will come together as a panel and discuss the case. This is going to take a lot of time. And then we will see what their order is. Because again, they're going to go from not every case even gets granted oral argument. Not every case gets taken up on appeal. We just saw it in Kouri Richins. The court refused to take up her appeal on the issue of change of venue. So from oral argument this week to the judges making an order is going to be months. This is not going to be quick. So I will circle back when we have an order on this and maybe take a look at some of the briefing on it as well. Charlie Adelson is asking for a new trial. This is not going to be his only appeal, I'm sure. We are going to see this continue to go on. We need to circle back on the issue of conflict. Remember, Charlie Adelson was arguing that his lawyers for his trial had a fundamental conflict because it was Donna who was in contact with them first. I think it is a fairly interesting and strong argument. I imagine when appellate counsel started talking to Charlie Adelson, appellate counsel was like, what the fuck is this? Because I really suspect that Donna's preferred counsel might have had a conflict in their allegiance to Donna before they ever started representing Charlie. Because other lawyers might have argued Charlie wasn't doing this. It was his mom. She's the one that did it. He was just a pawn of his mother. Mom did it. But if your lawyer has a conflict to the person you can point the finger at, it's a problem. And the day that Donna was getting ready to go to trial, the court was just like, this is a huge issue. This is a huge issue. Lona asked, but wasn't that Charlie's decision? I suspect that Charlie was not fully advised of the extent of the conflict. Yeah. And that is counsel who should have said, this is an unwaivable conflict. So even if Charlie Adelson tried to say, I waive the conflict, I agree, it might have been an unwaivable conflict. And counsel just was like, it's cool, let's roll. That might be an error on the part of the lawyer that has nothing to do with Charlie, where the lawyer should have said, I cannot take this case. I'm very interested to see where it goes. We saw it derail Donna going to trial in wild fashion. So we'll see. But, Law Nerds, I am sorry that I have to bounce. I have an appointment. Apologies for that. It's rare, but I have got to bounce. So for everyone who gifted memberships, thank you. For everyone who super chatted today, thank you. We have a ton on the docket for next week. I will be in touch in the app and in our member spaces. There is much to come. We have the Supreme Court new trial motion in South Carolina on Murdaugh. Y'all, I am fascinated. I am fascinated to see what the South Carolina Supreme Court does. And it is not just hey, they're making an argument to make an argument. On the Murdaugh case, there is a very real possibility that South Carolina changes their standard. And if they do that, Alec Murdaugh has a much, much better chance of getting a new trial. If South Carolina does not change their standard, he doesn't. But we're going to have to dive back into talking about constitutional law and what the standards are and the difference between the standard in South Carolina and federally. I think it's been like a year since we've talked about it. And then we will be in court watching those arguments. Plus, we have more to come. There are motions just flooding in the Kouri Richins case that starts jury selection Monday. That will not be televised. So as the Kouri Richins jury selection is going on, we're going to keep an eye on that docket. We're going to go to court and other things. There's stuff going on in the civil case in Karen Reed that we're going to circle back to. I think we're going to condense. There's a hearing. There's like a meeting to schedule a meeting that's a meeting. And then there's a subsequent meeting next week. I think I'm going to combine the two. And you guys, next week, this is why you need the app immediately. Next week, the sentencing is on calendar back in Virginia for Juliana Magalese. And we are going to be covering that sentencing together. So don't forget, we're going to get to the Juliana sentencing next week. And then this week, I will let you know we're going to be recording the podcast. We will be talking a little bit about Savannah Guthrie and her mother, Nancy Guthrie, because there's a lot that is going on in the seeming kidnapping, abduction of Nancy Guthrie. And the video that Savannah Guthrie put out yesterday is something we are going to talk about on the podcast, because it's very clear that the FBI is very involved in that statement, and that Savannah Guthrie and her family are asking for proof of life, which means that there was probably AI proof of life involved. So we're going to be getting into that on the podcast and what all those statements mean. It is really, really sad to watch, but we are going to talk about what we know from what we're seeing in the media. So we will be talking about that a little bit. It is really incredibly sad. And it's, I think, a good time to talk about the difficulty with anyone's voice and image being able to be duplicated with AI. And this is going to be a growing concern for courts. It's something I've talked about a little bit, that I am concerned how this goes when a defendant or witness or whatever gets up there and is like, that's not my voice, that's AI. We're already seeing that happen in cases. Seeing it happening in what looks like a kidnapping abduction case is sad. It's scary. And it reminds us that we are in a time when you maybe can't believe that the voice you hear that sounds familiar is actually that person. And that is a very different world than we grew up in. So we're going to be talking about that on the podcast this week. Make sure that you have the Lawnard app. Lawnards, you are the best. I appreciate you, and I will see you in the next one. Lawnards, take care. I'll see you soon. You're the best. Appreciate you being here. Thank you, mods. See you soon. Emily, hit the outro. I know. Bye, guys. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnard app at lawnardapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Lawnard.